So this has been edited and is effective at January this year. So this is different than the ones we've presented in the past by just a little bit. We'll kind of cover that as we go forward. Now you see that the cover page is the instructor's manual. That's just what I had to make that. But there is this document as a student manual, and you can download that, follow along, or when you're having trouble sleeping, you can pull that out. All right, lessons learned. Don't spend your time drawing. I'll just have to talk to you about it. Objectives. So this is how we're going to spend the 4 hours. We're going to talk about the rule updates, the statutory and rule updates. The statutory just means this is adopted by law in the state of Texas. We'll talk about the standards of practice. Now this afternoon, we'll go into more depth on the standard of practice, specifically with regard to the form. Then we'll talk about the duties and responsibilities of the inspector, ethics, and the hot topics, which would be just some things we've got coming up. Learning objectives under the statutory and rule updates. Understand your responsibility to know and operate under current laws. You know, we have enough disciplinary action to know that that's not something all of us are good at. We want to talk about the recent changes. This would be since 2017. Talk about, well, I'm sorry, first you have the Real Estate License Act and then the Real Estate Inspector Act, and we'll go into more discussion about that, and know how to be involved in the rulemaking process. Was that a question, Brenda?
No.
Okay.
We can hear you.
And don't be flirting with each other because we can hear.
Oh.
All right. Your responsibility. Well, it seems just logical, but that you need to know and operate under the laws. But we have a lot of times that people aren't doing that. Now, is it intentional or simply that they don't know? That's the purpose of this legal ethics update, and just a review is basically what it should be to you. When you have your license, or when you get your license, you should have had all of this presented to you. But I think what happens is that over time we focus on one thing and maybe forget some of the others. So there's two primary laws in the Texas Occupancy Code. We have 1101 and 1102. We'll go into detail, but you'll see that 1101 is about the real estate, everybody involved in the real estate, and 1102 specifically with regard to inspectors. I've talked about this in classes before and actually had more freedom to pull some stuff up on the computer so you could look at it. These are something that I have bookmarked on my web browsers. You don't have to download the whole thing. It's very easy to get to, very easy to go through, search for things, but you really should bookmark a couple of things. In the Occupancy Code, 1101, 1102, and then in the Administrative Code, Section R. Okay, so Occupancy Code, Chapter 1101, it gives the Real Estate Commission the authority to administer the chapters themselves. So the state has adopted this by law, but now they give TREC the authority to administer those chapters. That means that TREC can also create rules about those chapters to make sure that the inspectors are meeting the law with 1101 and 1102. And then finally, establish standards of conduct and ethics for all of us. It says all persons licensed under 1101, 1102. So there you would have your agents, your brokers, your appraisers, your inspectors, everybody that would fall under the a real estate transaction are covered under TREC, and TREC has the authority and requirement to administer those. All right. We've heard about the sunset agency review, and we've all seen some of the things that have gone on following that review. We've seen some changes. We've seen TREC's effort to make things happen a little faster with the backlogs and getting rid of the backlogs. A lot of that was a direct impact by Senate Bill 624. It's effective. These are all effective September 1, 2019. So you've been kind of operating with them, but keep in mind that these would have begun being presented last year. I think we made one live presentation before COVID shut us all down. So a lot of these changes have not been presented to you, and you may have gone out there and seen them yourself, but we haven't talked about them except in that very first class we had last year. So here are some of the things that occurred because of that. Chapter 1101, Real Estate License Act, requires TREC to dismiss a complaint if it's inappropriate or without merit. You know, that just seems common sense, but I think what you deal with in some of these is that there's a recognition that some things are not actually codified. So this is simply putting law to common sense, or actually, I guess, putting a rule to common sense. So if the various enforcement committees look and say it's inappropriate or there's no merit to it, they can dismiss it without having to do any additional follow-up. Requires TREC to protect the identity of a complainant. You know, we've talked about a lot of this in face-to-face meetings when I frankly said I think that there are some times that we as inspectors should pass on information on a complaint. That I have had in the past been reluctant to do it, but finally I saw some things that were just so egregious that I have myself turned into. Operating without a license was the primary reason for that. But this says that now TREC will protect the identity of that person. Maybe that'll make you feel a little more free to do that. I think the first step is always try to make that contact with the inspector and say, hey, you know, we got something going on here. I'm just bringing it to your attention. I've heard from some of you that have said that attempts to discuss that with the inspector were rebuffed. That's a shame. We have a responsibility to be professional. That's in the law itself. We have a responsibility to improve public's perception of the inspection industry. And if somebody calls me and says, hey, I see that you did this and that's wrong, I would hope that I could set aside pride and say, okay, today's the day I learned something. So if someone calls you with the complaint, with information about perhaps your performance, I think first thing you need to do is see if it's legitimate and react to it and improve your own actions. But then it also says that if we feel that we need to make that complaint, they are now going to hide that that information. Now, at some point, it will become known, but to begin with, it will be concealed.
Hey, Clay, I'm glad you said that, man, because for years now, I've been wanting to tell you some complaints I've got.
Well, Paul, let's just make a list and trade.
Good response. All right.
All right.
Go ahead, then, man. I'll leave you alone.
Okay, no problem. I'm just going to add that to your list. There we go. Removes the Texas residency requirement and instead requires geographic competency. You'll have to excuse me just a second. We have the morning trash pickup and they're quite loud to me. I don't know if that's bothering you, but give me a second. Okay, so what is geographic competency? Well, that's actually in the Texas Occupancy Code. It says that license holders must be informed on the local market issues and conditions in your geographic area. Well, you know, what is your geographic area? In my case, I consider it to be the greater Houston metropolitan area. And if I wanted to put a ruler to that, that's hundreds of square miles. And my geographic area is going to be different than the Panhandle. It's going to be different than a lot of areas. And I need to understand those things that are affecting me down here when I'm representing myself to a client. And then be informed on all those issues, including my specific area, but also national, state, and local. That's a part of what we're doing today, going over this. You know, I don't think there's a thing wrong with expecting me as an inspector to know what's affecting the industry. And there's two more requirements. Well, there's two more requirements, but they have specifically to do with brokers and agents. So when you talk about geographic competency, these are the two that are most important. Removes TREC's authority to license instructors, but maintains their authority to enforce the requirements. That means that even though it's not a licensed instructor, it should be a qualified instructor. The provider, in this case, would be InterNACHI to is now responsible to making sure that I'm qualified to teach you. And since I'm not, I'll be leaving now. Paul, no, okay. So I was license number 7. I'm just throwing that out there because Paul was number 9. When we had the license requirement to teach the mandatory or qualifying class to get your license. That's no longer required. I don't have to have that license anymore, but I still have to be qualified. That means we can't just put anybody to step up and do it. We need to make sure that you're going to get value out of that. Requires TREC to determine if an applicant is fit to engage. Whether we have moral character. Well, we've talked before about the fact we're going into strangers' houses, or actually we have homeowners allowing strangers into their house. I think it only makes sense that there be some measurement of our moral character. Perhaps it's less moral character than making sure that we don't have a background that says we're immoral. Every time I look at this, I think of Alice's Restaurant and the Group W bench, where somebody is put there to see if they're moral after having become a litter bug. All right, it might not be that extreme, but there's certainly cases where we would have somebody that's not one that we would want into our own house. That's why we have all the background checks. We have authorized TREC to deny a renewal. Now that's going to be the renewal of a license. Again, I think this is something that's simply codifying the things that have been done before, because if we had somebody that wasn't doing everything they were supposed to do, meeting all the requirements, whether it be for background check or the classes, you have now codified a way for TREC to say, no, you're not going to get the renewal. Okay, now we switch to 1102. And this says it gives TREC the authority to license and regulate real estate inspectors. And what it really comes down to is that the change in 1102 says that everything in 1101 applies to the inspectors. So remember, 1101 was about the entire real estate community involved in that transaction. 1102 is specific to inspectors. So the change in 1102 says that the changes in 1101 apply to inspectors. Texas Administrative Code. This is what I told you I bookmark. You can see all the sections down there. When I move my mouse over there, Paul, can you see that?
Yes, we can.
Okay, then that's the way I'll do it. So when you bookmark this, if you have to do some follow-up, this is where you would go to. You see that it says subchapter R. I would encourage you to read the entirety of it at various times. Too many times I think we stop with the standards of practice that start in 535-223, or even the little pocket size handout that, or the pocket size SOP book, which I still think is great, which starts in 224. Read through that because it talks about the licensing. It talks about and reminds you that you have to update information to TREC, whether it's change of address, change of phone number, change of sponsorship, any of those things. Those aren't in that little handout, but you're still required to know about those. Fees, the penalty matrix, everything else is in section R. Bookmark it and occasionally go through it. Publishes all proposed amendments and adopted rule changes in the Texas Register. Well, I'll sit and tell you that I don't just pull up the Texas Register and say, hey, what's going on today there? But you'll find that there are proposals that you find you are notified of in Inspector Insight. And Paul and Brenda do a pretty good job of letting us know that there's some changes coming down the pike. And you can go to Texas Register and see those as proposals. We'll talk here in a second about the things that you as an inspector can do to affect the rulemaking process. Well, the very first and most important part of that is knowing what are proposed proposals, and then you can react to those proposals. If you ignore it until it becomes law, then you're responsible for upholding the law. Inspector Insight published 8 times each year, and that's just sent to you as a link on an email. Everybody should be logged in, not logged in, but signed up for all of that. You can do that through the TREC site, website. This is where you, Inspector Insight is where you learn about not only the proposed rules, but we also see disciplinary action that is worth reading just to make sure you're not doing something somebody else got in trouble for.
Hey, Clay,
Yes.
if they're not receiving this inspector's insight, then it's probably because you don't have them saved in your contacts of your email program. So it may be going in your junk files, or you may not have the correct email address at TREC. So you probably want to check that. If you're not receiving them, I'd start first checking and see if you have your correct email logged into the TREC's information on your file.
Make sure you have saved trec.texas.gov, I believe, as a safe sender, safe recipient, so it doesn't go to junk. Then, as Paul said, check to make sure that you have the correct email on file. And we've talked about that before too. Every now and then you just need to go and check. We've seen many inspectors where they did not have their DBA posted on their profile. So take a look at it. And I still think that there's a place that you have to actually sign up for that, or can sign up for that. It pops up every time I load the TREC website. Okay. So this is a link. It is a tab, a link, a page on the TREC website, specifically talking about the rules and law. This is where you can download, or actually not download, but you can go to that page online to read through all of that. This is a good starting point for any research about the laws. Rule changes. All right. And this is going to be the Texas Administrative Code, and again, since 2017. Clarified the process for renewing an expired license when it's been expired for less than 6 months. Once you go more than 6 months, you sort of default back to being a brand new applicant. You have to go through all those hoops. So if you can take care of everything within 6 months of the expiration of your license, it'll be much easier for you. So the amendments clarified that process. Non-elective coursework, the requirements were updated to include basically what we're doing today. The developed by providers part is what we do this afternoon as a standards of practice review. And the 4-hour course developed by TREC is what we're doing right now, which is the legal ethics aspect of that. Ride-along course. It allows inspectors to receive credit for doing these. I'm sorry, I'm reading that wrong. So this is two things. It revises the definition of a ride-along, but it also allows inspectors to receive continuing education credit if you are doing that for a license in Texas for another, whether that would be, I guess, pest applicator, that would be one. So if you get some continuing education for one thing that's licensed in Texas, you can possibly get continuing education credit for your inspector license. Corrected a clerical error. We have, it's pretty straightforward, but it does mean that people are going through this and trying to make sure that these standards of practices are correct at all time. Added a specific definition for standard of practice. This goes back to when the standards of practice and legal ethics update was first introduced. Since then, it's been restructured because originally it wasn't created by TREC, or the legal ethics part was not, and it's been redefined and broken into the two pieces as we present them today. Definition for client was added. The client is not always the person who is paying for the report or the inspection that you might be doing. The client is the buyer or seller of that property without regard to who's actually making the payment to you. So when I have had, yesterday, as a matter of fact, an individual was buying a house for someone else. So who was the client? Well, the client was the person who was actually going to own the house after the transaction. So just it's rare that something like that comes up, but the bottom line is the definition of the client is the buyer or seller of that property, and not who is making the payment to you. Unused definitions, code code organization and trade association. Those definitions were deleted because they weren't used in the TAC. This was a part of just reviewing and revising the standards of practice, specifically 10 students per instructor to 4 students per instructor in the ride-along program. I was a part of a ride-along as an instructor when there were 10 students, and that was just absolutely untenable. It wasn't a good way to try and teach, instruct, or mentor any of those. So it's reducing it to 4, and frankly, I think 4 is too many at times, depending on how you instruct and how you are trying to, instruct or mentor. It says you can have multiple instructors. It allows that, but it goes back to, I think it's a very difficult way to instruct too many people talking too many times. We have a question over there. So how do you get credit for having new inspectors doing ride-alongs? There's a specific form. If you are the student, there is a form for you. If you are the instructor, there is a form for you. As an instructor, what you're saying is that you had these or this potential inspector in a ride-along for this many hours. And as the student, you need a form per event, and there are definitions about how long you have to ride, how many full inspections you have to accomplish. So you have to have at least 1 full inspection per 8 hours of ride along. And as an instructor, exactly the same thing. There are the forms that you will find as a search on the TREC website. And Brenda, if you want to kind of search for that, or I can do it for you during one of the breaks. So the client would be the person. Yes, for Charles. The question is, so the client would be the person the report is being prepared for, regardless of who is paying, and that is absolutely correct. Many of you may have had an agent who says, this is the buyer of the property. You're doing the inspection for them, but I am paying for that. And some have said, I'm doing it just because I like them. I want to. It was a phase inspection. It was my recommendation. It doesn't matter. It's just maybe because they're just nice people. But if the agent pays, my client is still the buyer or seller of the property. That's just housekeeping. Added a section to the penalty matrix. This is also housekeeping. What they had are two different code sections, and they just linked them together. So it'd be 535.220. Now it goes back to 531.18. And if you're keeping track of the numbers, what you'll see is 535.220. The section we're discussing here is a part of section R. And this section 531.18, much earlier in this section, has to do specifically with, or not specifically, but generally with the Real Estate Transaction Act. So it just says that the 220 section ties back to the 18, just so that they're not in conflict. It depends how much you read section R, but in section R, under the licensing section, and again, this isn't in the pocket handout, it shows you which courses are required to renew your license. The courses have changed because in February 28, you're going to see changes in those course requirements because the number of hours for various courses have been reduced for getting your license. So this is just repealing that old piece because you have the new piece coming on board. So 220 replaces 213. Don't forget to read Section R, guys. It's very interesting. The minimum requirement for receiving continuing education requirements. There's a certain limit to the number of hours, and you are also, there are some that can be excluded, some with certain, well, let's say, specifically, I had an engineer that wanted to do a ride along with me because he's getting his license, and TREC has allowed him to substitute his engineering experience for the ride along courses. He still wanted the ride along courses, but he was able to forego them if he wished. This is about the Texas Real Estate Inspector Committee meeting, and you can receive up to 4 hours of credit per license period. So that means 4 hours every 2 years if you attend any of the inspector committee meetings. Reduces the amount of time that an inspector has to deliver a report, but it also clarified, or actually now allows us to not deliver the report until payment is made. So you're not forced to deliver the report if you haven't received payment. Even though you now only have 2 days. So if you have prepared the report and 2 days goes by and you have not received payment, then you don't have to deliver the report. But now 3 days goes by and you receive payment, that report is due immediately, not another day, not another 2 days. It's due immediately. But at least we're protected from delivering a report, at which point we have no security. Once they have it, they don't need to pay us. 2 days, but you have to receive payment. The license exam, there's 2 parts of it. You have the state part, which emphasizes the Section R, the licensing requirements, the education requirements, the penalty matrix, and the standards of practice. But you also have that national part, which is from the National Home Inspector's exam. And that is a separate test. And you now do not have to take those at the same time. So study for one, take that test, study for the other, take it. Note that if you take them separately, though, the national portion has to be taken before the state portion. It also says that if you fail the examination 3 consecutive times, you can't just sign up for another test until you've taken some additional courses. So you have three shots at it in a 6-month period, and then you have to do some extra work. This goes back to the discussion we had a few minutes ago that says there are specific courses that are required. And this is simply saying that you have to complete the course before you take the exam. I already said that. reason I'm repeating this is I was looking over at the side in my presenter view and I saw my notes. So I was thinking that note was specific to that one slide, but here we have it, just the same things that were in my notes. So if you fail 3 times, then the courses you have to take are very specific. It's not you just pick some courses to take. You fail 3 times, here are the specific courses that you have to take. Currently, 3 license types: apprentice, real estate, and professional. Well, go back and you see effective August 31, 2020. So it is no longer that there are 3 kinds. We now have real estate and professional. No, I'm sorry, we have apprentice and professional. That's what it is. We have apprentice and professional, eliminating this one in the middle. And what that's doing, or what it's intended to do, is make sure that those that are coming into the business through the apprenticeship program are getting more hands-on experience before they can become that professional inspector, getting more oversight, getting more mentoring, and hopefully preventing that situation where we have somebody that's thrown out into the field with just enough licensing to get into trouble. I'm sorry, I'm looking over here at a question. I think, Michael, I think we answered your question, but I didn't look over here. The question is, what if a client pays me 2 days before the inspection? Do I have to deliver the report immediately after the inspection is complete? Or what if they pay me 1 day before the inspection? No. Once you do the inspection, you have 2 days. The restriction is only that you do not have to deliver it until you receive payment. So if they pay you 2 days ago and you do the report today, you have 2 days. If they pay you 1 day ago and you do the inspection today, you have 2 days. Paul made a comment that the report can be due later than the 2 days as long as there is a written agreement.
Actually, Clay, I didn't write that in there, but that's not a bad comment. I don't know, someone must have sent them my link and they're using my name as they do it. So be careful whoever's doing that. All this is being recorded.
Well, it says it's under you, Paul, so.
I know, that's a scary thing. I'm not that polite, Clay, you know that.
Well, you don't type that well either, so that can't be you. All right, that's interesting. I don't know where that came from if it's not from Paul, but there you have it. More experienced license type real estate professional can be attained through experience, sponsorship, of coursework. That's really no different. Okay, so 535-212 has consolidated the information about total hours of coursework, total hours of field work, substitute paths, puts it all there, and it makes it consistent with other requirements, or with the requirements in other states. I do nothing to look at the requirements in other states. I've got enough to do to keep up with mine, but what this would be is just to make our inspectors more consistent with other states' inspectors. Now, I have heard that we've had 1 or 2 inspectors at one of the, I think it was the Houston chapter, that had reached out to several states to find some information and see how it how consistent it was with Texas. Apparently they have more time than I do, but that was very good to hear. Removes the requirement to repeat coursework for higher level license. So if you took a course to get your first license and you wanted to get the test for the next license, it used to have that you had to take that same course again. So this just streamlines it, makes it easier. This is how they reduce some of those total hours that are necessary to get your license.
Hey, Clay, we have a question that probably backtrack a little bit, but they're asking about the ride-alongs, and then they talk about having a virtual ride-along due to the COVID. And I know that did exist and may still exist, but you know, there were certain limitations on how they did that. It had to be kind of a live deal where they could communicate back and forth with each other, like a FaceTime or something. But the other question was talking about time to deliver the report to the client. It says, what if they haven't sent back a signed agreement yet? And, you know, at that stage, I think if you did the inspection before you got the signed agreement, you still only have those 2 days, right?
That's correct. There is no law that says that you have to have an agreement or that the client has to sign the agreement. So if you're going to protect yourself there, then what you would have to do is not do the inspection unless the agreement is signed. So you show up to the site and you have an inspection agreement that's not been signed, present it to them right there and say, I need this signed before we continue. If you do not get that agreement, then you're entitled to walk off, though I think that would probably create some it would certainly create an argument, I would guess.
Yeah, and Clay, one thing on the agreements from our legal classes that we've had recently, the attorneys tell us that that agreement should be in the potential client's hand before you get there to do the inspection. In other words, they need to have a chance to review the agreement.
Right.
So if you're taking the agreement with you to the inspection site for them to sign it, they actually would have an out saying, hey, I didn't have time to have my attorney review it. So,
and my comment there is, if you show up and see that they don't have the agreement signed, you can present it to them for signature, but it can't be the first time they've seen it. I think all of us send that agreement out in advance, and you certainly should, to give them that 24 hours.
that's cool.
There are times that I've had a, hey, I need you and I'm available tomorrow morning, and there is not 24 hours for them to review it. I still send it to them and I still expect it to be signed. And then we'll just have to deal with the rest after the fact. But no requirement for an agreement. So this is the instructor providing the student a document saying that they have taken X number of hours, and then the student would submit this to TREC as a part of their licensing request. So if you can see it, it's not too big, but at the bottom it is INS-RA-CRT-2. And Brenda, if you looked it up, you might want to just post that on one of the Q&A pages. The second document is the instructor asking for credit for having provided the ride-along. So this would list the students and say that on a certain date, X number of hours were provided, and it would be typically 8 hours. Though I know there's some out there that are doing 10-hour ride-alongs. So these are the two forms. This one is INS-RA-INPI-1. Do you want me to leave these up, or is that enough? Brenda, can you type that out there? Okay, I'll do it.
She'll put it in there, Clay, just a few minutes. She just stepped away for a second.
Okay. So I think that answered the last pending. Okay, so we answered the question about the ride-along. I think we've answered the question about virtual ride-along, signed inspection agreements. We have someone that made a comment that InterNACHI has an inspection agreement that they are providing if you choose to use it. There's another one that Paul has shared that came from an attorney. That's a very good agreement. So there are a couple of places that you can get agreements. If you don't have one, check out InterNACHI's.
Right. And Clay, one thing about that question, I'm not sure if I'm looking at it right, but maybe an explanation. They're talking about the InterNACHI standards of practice. In Texas, we have to use the TREC standards of practice. And InterNACHI is okay with that.
Okay, so I think you are reading it. They're just saying that you can modify it. They're providing you the inspection agreement that they've given you permission to modify. So it is specific to Texas.
Correct.
I don't think I'm going backwards, but this sort of looks like what we've already talked about. Detailing the specific coursework required for a new license. I've had many people tell me that it's the national test that's more complicated than the Texas portion of the licensing test. And I think it's because everything I've seen for the Texas test is very specific to the SOP, and it's pretty black and white. Once you understand section R, or those pieces applicable to the licensing, you're good. But everything I've seen about the national part, I've seen questions I disagreed with, or I see questions where I disagree with what's the final answer. It doesn't match code. It doesn't match some other things. Their study guides for the books are not clear. So the national part seems to be more complicated because the study guide is less black and white than I would like to see. An amendment to the consumer protection notice. I don't know if you can see behind me here. Well, I wanted to unblur it, but perhaps you see behind me those 3 documents that are posted. I did that sort of out of silliness, but those are the ones that we're supposed to have in a place in your office. An amendment to the consumer protection notice alerts consumers that inspectors are required to have the E&O. Let's see, I think I've got this here. There you go. So that part that is highlighted by the blue box is what has been added. And it says that we have the E&O requirement. And it also says in this section portion, the second portion here, that we may have a contract, we may have an inspection agreement. Now, you see that it's not saying that we're required to, it's simply telling the consumer that the inspector you use may have an agreement that is a part of their inspection. So everything that was that is not inside that box is a part of CN Consumer Notice 1-2. 1-3 includes this amendment. So how can you get involved? Well, that's a discussion section. So since not everybody is, we're not in a classroom, I don't know that we should do this with chat, but I guess we could. Anybody want to type something in there about how to get involved? Apparently not. Okay, well, attend the IEC, visit TREC commission meetings. Good. What about simply, there we go. That's what I was going to say. What about just emailing the IEC? Responding to some of these, reading those proposals and make comments about them. Excellent. Get involved in local chapter meetings. That's great. I know that we have, that doesn't specifically affect the rulemaking process, but that's a great way to make sure that everybody understands the proposals. If we get together and somebody says, what about, you're going to have an inspector who wasn't aware of it. You know, the chapter meetings have suffered a lot during the COVID process, or the COVID lockdown, if you will. Not as much getting together. I think we're starting to see a comeback. It's just now we may be out of the habit of attending those. Those chapter meetings are great give and take. Even without a specific presentation, those have been excellent ways of sharing. I've gone to chapter meetings where all of a sudden we find out that the presenter couldn't make it. And those have been some of the best discussions when it's just Q&A inside there. All of those are good. Okay. What kind of continuing education is accepted? We can do that through the chat as well, but this might be a little bit more complicated. Continuing education in another state, as long as it's got to do with inspection, teaching courses, the ride-along instructor, and then in attending the TREC meeting in February. Now, that, remember, you get 4 hours for the inspector committee every 2 years, but you can also get it for attending the full TREC commission meeting. Make chapter meetings more central to attract more inspectors. The whole idea of the multiple chapters has been to try and make it easier for inspectors to get to them without traveling for many hours. I think Houston now has 4 chapters and they're all kind of spread out. Some of the areas that are more rural, you have to travel further. Problem with the chapter development is the same as it has been with TPRIA. It's getting people willing to step in and take leadership roles in more than just title. We have had these chapters where all the burden has been on a few people, and that's what we faced at the state level. So if you want the chapters to work, it's going to take involvement. Okay. I'm not going to try and keep up with the chats there, but that's all some great comments. What are the requirements for instructor ride-along? You have to have had at least, you have to have completed at least 200 inspections. You have to log those 200 inspections. You have to provide that log to TREC along with your application to become a approved ride-along instructor. You do get credit for providing a ride-along or being an instructor, but there are limits to how many hours you can get doing that. In the same manner, you can't take 32 hours of education in electrical work and get credit for that 32 hours. There's only so many hours you can get for being an instructor, so many hours you can get for an electrical course, so many hours you can get for attending a committee meeting. The whole idea there is that you should be broad in the continuing education rather than focused on one simple thing. Okay. Standards of practice. This is what we're going to accomplish in this chapter of the book. And I hope everybody does download that student book. We're going to talk about when the SOPs apply, talk about the departure provisions, describe substantially completed, and talk about the form. And then remember, this afternoon we'll talk about nothing but the form. So help me God. The SOPs apply to an inspection conducted by an inspector that's licensed for the prospective buyer or seller of a 1 to 4 family unit that is substantially complete. Okay, so what do we eliminate? It is not an inspection of a foundation before the concrete's put in, a phase inspection. It is not an inspection of a home that is in an open frame condition. Substantially completed means that somebody should be able to live there. That would say that it is a resale. It is a final inspection on new construction. It would eliminate, I'm not going to use the warranty inspection because calling it a warranty inspection might imply something to the client that you are providing warranty. I think the best way to talk about that is the 1-year inspection, where you are offering to do an inspection of the property before the completion or before the end of the builder's warranty. That means if you're doing that type of inspection, you do not have to do it on the TREC form to the TREC's SOP, though sometimes it might be a good, valid way of doing it. It, in my opinion, would not apply to condominiums because that's more than a 1 to 4 family unit. But I've been told by somebody that was on the inspector committee that it did include that. Regardless of whether it does or doesn't, it seems to me that performing the inspection to the SOP and reporting it on the standard form, it keeps me out of trouble. It's a good way to tell the client this is what we're inspecting to, and here's how I'm reporting it. So even though it might not apply to a condo, I ignore that and do it on the standard form to the standards of practice. Subject to the real estate transaction. Again, that's the buy, purchase, or sale of a property. Do not apply to systems or components not within the SOPs. I'm sorry, I'm looking at a chat here. I do a lot of condos, but exclude the evaluation of roof and foundation and follow the other guidelines. Excellent comment. You're doing the same thing I am. You're following the SOP and you're using the standard form. But when we get to the discussion this afternoon about that, I hope you're not deleting those sections. You simply would mark that they are not, they're not inspected, or that they're not present. An example would be a condo on a second floor of a three-story building. It doesn't have an attic space. You can say that the roof wasn't inspected and you can say that the foundation wasn't inspected, but they are present. So we'll talk about that later. Do not apply to systems or components not listed within the SOP. So what do we have there? There are a lot of appliances that aren't specific, but there's a section under appliances that says other appliances, other systems. I guess what I would think of offhand would be a trash compactor and an ice maker. So it might not be specifically applicable, but if those are there, you certainly should document that they're there. And if you inspect it, it would be doing it in a normal mode. So for a trash compactor, it might be as simple as stomping the pedal or hitting the button and see if it compresses anything or even pretends to compress anything. Solar systems, those aren't in any way mentioned in the standards of practice. And I would document that they're there and didn't inspect it. I did not inspect it. Gas fueled generators, things like that. If it's not listed, the SOP isn't applicable because there's nothing to gauge it to. And if you tried to inspect it, it would have to be based on whatever knowledge, experience, and outside certifications that you have. Do not apply to cosmetic or aesthetic conditions. I think we've all been in an inspection with a buyer in new construction, and they want you to mark every little cosmetic thing that there is. Well, the standards specifically exclude some things that are cosmetic or aesthetic. And one of the first things I do is tell my client, that's not what I'm looking for. And I'm not going to put it in the report. They want me to document all that. And I tell them that if I start putting those things in there, then the builder will quit reading the report, as if they read the report anyway. That there's nothing to stop them for discussing cosmetics with the builder, but that's not what I'm there for. And that keeps me out of trouble with the client, not with TREC, but with the client for, oh, you missed this and that doesn't look good. You missed this and that doesn't look good. Floors are excluded. Floor covering, which would be carpet, things like tile, things like wood floors, unless of course it's not a damage to the wood floor from normal wear and tear, but from something like moisture. And then if I had carpet that was wrinkled and it becomes a trip hazard, I'm not worried about the condition of the carpet. I'm worried about the trip hazard. And so I would report that I see a trip hazard, and it might be corrected by tightening the carpet, stretching the carpet, or replacing it. But I'm not saying it's the carpet that's bad. I'm saying that there's a safety hazard. When are they not applicable? It's a limited visual survey, basic performance evaluation under normal controls regarding the general condition of a residence at the time of the inspection. So this isn't an all-encompassing inspection of absolutely everything. It is not a diagnosis of the problem. It is not trying to find the cause of a problem. So if I report a wet spot on the ceiling, I don't necessarily have to go and find out where that wet spot came from. I can certainly say I suspect that the air conditioner sitting in the attic space immediately above this created the damage because of condensation. And then when I'm inspecting the air conditioning equipment in the attic, I might be able to prove that. Same with regard to a water heater, same with regard to visible roof damage. But if I can't prove where it came from, I'm not required to continue to diagnose it. You have water damage. Yes, I think it came from the AC. Yes, I think it came from the water heater. Yes, I think it came from the roof. Or you know what? I can't tell. You might have water pipes there. You might use that water spot to see if you can't find a deficiency. But if you don't find the deficiency, you're not required to. Same thing with, I think the most common I have with this is a second floor slope. Now we might be able to look and see that a load-bearing wall doesn't have a load path all the way to ground. But at that point, I am not an engineer and I don't tell the client that the floor is collapsing because of the lack of a load path. I don't tell them that it looks like your floor truss is coming apart. I say there's a floor slope, and they need to, at that point, have an engineer look at it, and it might, and most likely will require removal of floor covering or ceiling covering. So in phase inspections, other than the final one, they're not required to be on the TREC form and are not regulated because they're not completed, i.e. pre-pour, pre-drywall. That is correct. This is in the Q&A section. That is correct. TREC has nothing to do with pre-pour and nothing to do with pre-drywall, and they have nothing to do with that one-year inspection. If you are doing those, I strongly encourage you to have code certifications, because if you're ever held accountable in court of law, they're going to want to know what was the basis for your inspection, what was the standard of practice you followed. You're not following TREC standards of practice. You need to be able to prove that your inspection was based on something and that you have some knowledge, or you have enough knowledge to present yourself as qualified to do that inspection. Okay, I think we're caught up on that. SOPs establish a minimum requirement. There's nothing prohibiting you from doing more. It's just saying you can't do less than this. So we have those that might be doing a thermal inspection. We'll talk about sewer scope inspections later, but that would be additional. We have those that use a drone, but I'm not saying that the drone is a greater level, a higher level. They're simply using a drone to do the minimum level of inspection on the roof. However, that drone certainly might be able to get to parts that you might not otherwise see. Higher level of inspection might be an energy inspection. You're not required to do that in the SOP. I think we'll see some of this in the discussion, so we'll leave it for that. Departure provision. So there are times you simply can't do something. The SOP requires you, but you can't do it. So when can you depart from the standards of practice? Well, you agree that it's not to be inspected. Have you ever had a client that said, don't worry about the kitchen appliances, I'm going to replace them all? I'm glad to hear that. That's just one more thing I don't have to inspect. I'm happy to click not inspected, but I also document why it wasn't inspected. Not inspected, client instructed, or client simply said, don't inspect that, whatever you want to say, but I don't do it willy-nilly. I didn't inspect it. Here's the reason I didn't inspect it. I'm not qualified to inspect it. Well, how about solar panels? I'll throw that out there. If somebody has a solar panel and I've only come up with some of them, I'm going to tell the client I know nothing about them. I think I've seen 2 solar panel systems. I know nothing about them. And I'm not ashamed to say that. What about generators, natural gas powered generators? I have learned more about them. I've taken some additional instruction about them. I have a nephew that is in the business. He does a tremendous amount of business, and he has been kind enough to give me some information, but that doesn't make me fully qualified. Mostly what it does is give me more information, tell them that I see this that might be wrong, and they need to get somebody else to look at it that is qualified. Common element of a multifamily development. Well, we get back into the townhomes and condos that there was a discussion a while ago, or chat a while ago. You exclude that because you can't get to it in a condo. Absolutely. That's a departure. Conditions exist that prevent the inspection of an item. Okay, let's, I want to answer a question on the chat. If I do an 11-month inspection and choose to use the TREC form for the report, am I then required to comply with the TREC's SOP? No.
Clay,
Go ahead.
You know,
Say it again.
why would the answer be no on that anniversary inspection?
Because it's not a part of a sales transaction.
Okay. That's what I wanted you to bring out on it. Brian also asked a question just above that one. I don't know if you see it. Talk about been some chatter about walkthrough or walk and talk type limited inspections.
Okay. If there is a sales transaction, you can't simply do a walkthrough. You have to do the inspection following the standards of practice using the form. The difference would be the 1-year inspection. I have, and don't mind doing it all for pay. I will tell the client that I will walk through the property with them, point out, talk about things that might be warrantable, but I will also tell them things that they should do for maintenance. I will talk to them about the house. Basically, I walk through and do everything I would do in an inspection except make notes and write a report. I enjoy doing that, frankly. I enjoy talking to the clients and teaching them about the house and not having to write a report. But that's not a part of a sales transaction. I could not do that with a client that says, I'm buying the house, I don't want you to write a full report. Can you just walk through the house with me? No. Sales transaction, if you are taking money from them for an inspection, you follow the SOP and you use the form.
Yeah, and what if, Clay, someone calls you and says, hey, why don't you come inspect my house? It's not on the market yet. What What kind of report would you need to do then?
Well, according to TREC, in discussions that we've had before, they have said to you they intend to put it on the market. Once they tell you that they intend to put it on the market, you're now required to follow the standards of practice, because they're basically using that report to prepare their house for sale. And remember that they are required to disclose that they have a report that's less than 4 years old. So what they're trying, what the rules, the laws are trying to prevent there is somebody from having an inspection and then not having to disclose the inspection or what was found.
That's correct. And a lot of times when I get that kind of calls, Clay, I will explain to them, you know, if they have issues with their house that they're aware of, we come into the written report for them, then they have to disclose it. Most of the time they decide they really don't want us to come do that inspection.
But if I am doing a warranty inspection and they want a report, I have to follow the SOP. Technically, no, because the SOP doesn't apply, but they want a report. I would suggest if you're writing a report at a 1-year inspection, you follow the SOP, because what's going to happen if they go to sell the house, they now have a report that doesn't follow the standard of practice, and you would be in a position of having to defend yourself. So if a report is generated, and I have done this, they did not have a final inspection. So that means the report being created at the end of the 1 year for warranty purposes, I'm going to follow the SOP and prepare that report. It is only when they don't want the report at the 1 year inspection that I'm willing to walk through and just talk to them, not generate a report. And I still follow the SOPs in terms of what I'm discussing with them. So the answer is, yeah, you could get away with not following the SOP, but that would just cause you problems down the road, I honestly believe. So conditions that prevent the inspection of an item. We had thunder and lightning yesterday. I didn't go up on a roof. Looked at it from the ground. I didn't even get the ladder out. I did everything from the ground. And that was perfectly okay. And the client was perfectly fine. And I told them when it started raining and lightning and thundering, and they pulled up in the car and I was standing there with an umbrella, I said, I'm not going to be able to get on the roof today. They were fine with that. Attic spaces. My report has a disclaimer in the early part of attic and roof structure, at the very beginning of attic and roof structure, that says that I cannot get to all portions of that attic. And I think it's important that you have some sort of disclaimer, something there. Otherwise, there is that expectation that you inspected the entirety of the attic. How many people are, how many of you have faced the situation where the homeowner has cars in the garage? They're not there, but they have cars in the garage and they are underneath the pull down ladder and they block the electric panel that's also in the garage. Or there's no cars, but that's where they store all their personal stuff, because the agent said, move all that stuff out of the house so the house looks bigger, easier to sell. They put it right in front of the electric panel. What about a reinspection? There is the information, there is a blurb, a comment that lets you say that you're only inspecting a single component. What it's essentially doing is you're re-inspecting this. You can use the blurb to show that you're only inspecting a certain item. You need to make it very clear that that's all that you're re-inspecting. Otherwise, there might be the expectation that you've looked at everything and should have caught conditions that changed.
Well, that is so true, Clay. I did an inspection sometime back, and the house looked really good. People had painted, made it look, really look good. And I had written up a few areas that looked like moisture and probably had the old mold issues going on. And I told the client they needed to have further evaluation by, mold specialists for it. But when they went back after the people moved out and they walked through the house just before going to closing, they saw that the sellers had actually put up some boards around the cabinet's interior, and the cabinet, as they opened the refrigerator was gone when they came back for the walkthrough. They saw moisture stains on the wall. Well, they got to looking, and the whole cabinet, the people had put false fronts on the interior of the cabinet sections. And when they moved it off, the whole cabinet was full of mold. But I mean, those type deals are something that we wouldn't observe during an inspection, typical home inspection. And, they certainly understood that. But, a lot of times furniture, and on the opposite side of the wall, they had a big dining room buffet cabinet setting there. So when I do an inspection and the house is occupied, I will put a note in there that there is furniture, objects, even storage items in the attic or in the garage or whatever that do hide the view of those areas from the inspector at the time of the inspection. And they should, check it out again once the people move out before they go to closing. So I always put that note in on an occupied home for those reasons.
Well, when we talk about the inspection form and when we talk about one of the other documents, Texas Real Estate Consumer Notice, we have some protection in there, but we know that the clients don't read everything. So when I have a section like that, I absolutely document that I'm not seeing everything. My inspection agreement says I'm not seeing everything. I have a comment on the Q&A section. I take pictures, absolutely. I've talked to you about pictures before. When I started in 2004, I was taking about 35 photographs, and the photograph was, this is wrong, and this is wrong. And over the years, I realized what's just as important is a photograph of this is right, and this is right, or I couldn't get to it. Right now, new construction, 125 photographs. Resell, 200 photographs. Resell with a problem, a large house, 300 plus. Memory is cheap these days. When I started, the memory card, the camera was $300 and the memory card was $80. And today, if you sneeze, a memory card pops out. So it's not a problem. I store everything. Right now, I have close to 2 million photographs. I'm a photo hoarder. That's what I am. Stay away from classic cars. It doesn't have to be classic. If it's expensive, I stay away from it. And I take a photograph of it. Muddy crawl space. Oh my gosh, yes. But even more so, a muddy crawl space beneath a plumbing pipe, because I don't know where that water came from. Take a picture of it. Seller refused to let me in a closet attic access hatch. Said you had to use the garage stair. Problem was, you know what I do there is I document it. The seller said, the seller refused. I want that to be very clear that it wasn't a choice I made. They're the ones who said I couldn't get in there. So if something happens later, there is a defense from the buyer, my client, that the seller may have known that. Put the burden on them. Rather have one photo too many than not enough. Absolutely. All right. Conditions that prevent the inspection. Hazardous to the health. Thunder, lightning, the height of a roof. Don't want to crawl across ceiling joists. I don't know if it's that I'm not as brave as I used to be, or maybe I'm just more reasonable than I used to be. But I recognize now that there's some things that just aren't worth the risk to me to try and inspect. I don't monkey walk across ceiling joists the way I used to. Live to inspect another day. Absolutely. Attics, I think, are the biggest problem, the most risk. All it takes is a slip or stepping on what looks like it might be decking and have it be not thick enough or not secured.
You know, Clay, sometimes that happens when we try to get too in depth and try to be, let's say, a better inspector than what the norm would be. We go past the minimum standards. And I had a gentleman tell me just the other day that his dad was a home inspector, was inspecting an attic, and there was an area that he couldn't see very well, so he forced himself to walk atop the joist and try to not step through the ceiling. Well, he did step through the ceiling. When he fell, he broke his neck, and now the gentleman's paralyzed from neck down. So guys and gals, sometimes whenever we all want to do a good job, but sometimes whenever we push it to the extreme of trying to say, hey, I'm a really great inspector, sometimes that may cost you something. Like this guy, it cost him not just his career, but the lifestyle that he'd been used to. I mean, it changed in just a moment's time. So let me please ask you to be careful when you're out there and take care of yourselves. I mean, if you can't see an area, just write it up. You can't see it, but you don't have to force yourself to go around and see something like that is hazardous to you. So just a word of thought there for you.
What I have found is that when the client is with me and I point something out and I say to them, I just don't think that's safe. I've never had a client that says, oh yeah, you can do that. I think you can get up there. That's not too scary. Not once. So I think if you point out to your clients that there is a reason that you're concerned, everybody's going to be reasonable. The comment is made is, if you find an area inaccessible, unsafe, or hazardous, just say that in the report and show a photo. Absolutely. Problem I have with photos in the attic, though, is those areas you're trying to show that are unsafe and you can't get to are so dark that the photos come out as this big black spot. But do everything you can to document it. Actions of the inspector could cause damage to the property. I think pretty much everybody has caused damage to a property at one point or another. It'd be nice to say that that doesn't happen, but we make mistakes. Sometimes it's inadvertent. The comment being made here, or the issue here, is that you are recognizing ahead of time that the action could cause damage. So we all need to be on the lookout for those things that might damage something, whether it's stepping over a ceramic donkey and that's a different story. Or walking across joists where you could slip and go through, or it's moving something out of the way so you could reach something. Just be smart about it. Is an inspector's E&O responsible if he or she inspects their apartments or rentals for a real estate company? That would depend on the terms of the E&O insurance. That just means you need to be very aware of what your insurance is covering when you're purchasing it. I don't test auto reverse on a garage door opener if the door is damaged. Absolutely. If the door is damaged, usually we're talking about at the bracket where the automatic door operator is connected. If it's damaged there, something happened, and usually my experience says somebody locked it and then tried to open it so it folded in. Well, any force that you put against it is now just going to cause that to bend even more. So the first thing I look at, in fact, is the lock engaged? Is the lock fixed so it cannot be engaged? And then I look up at the door where it comes together, and you'll see that somebody screwed it up before, and I just back up. I'm not going to do that. Temperature and pressure relief valve. Give me 1 second on that. Boy, some of these things are going through fast. Let me answer the relief valve. First and foremost, you're required to inspect the relief valve. So if you choose not to do it, you're using a departure. If you're departing, you need to tell them why you're departing and what might be missed, or actually just why you're departing. So I'm not testing the relief valve. What's your justification for that? Not testing it because it might not reset. Well, I think you would be hard pressed to justify not testing a relief valve on a brand new water heater. So at what age do you determine that it is no longer easier? At what point, at what age do you decide it is a risk? Well, the manufacturer of the relief valve typically says that it should be inspected annually, and that 3 or 4 years, depending on the manufacturer of the valve, it should be removed and inspected by a plumber and replaced if necessary. So at that point, I think that you have 3 or 4 years. If it's older than 3 or 4 years, you could justify not testing it because it might not reseat. Another thing that might keep you from testing it is that you don't see where it discharges. It should go to the outside. And since I personally do the outside first, I am looking for where it discharges. If I can't find that, now I'm a little concerned about testing it. And the third is that if there is a T on the discharge line of that relief valve, and there's not supposed to be a T, and the T is generally where it goes back into the safety pan. If you test the valve and that primary drain is backed up, it leaks into the safety pan, and then it can rise and overflow, and you get the call at 10 o'clock at night from the seller because it overflowed and damaged their shoes. So if there's a T, I don't know where it terminates, or if it's an older valve, I think those are excellent reasons not to test the valve, but it all comes down to a decision you have to make. Other than T and P valves, sprinkler systems. I don't know that I could justify not testing a sprinkler system, because if the head falls off, you've got a problem. The water goes everywhere. It's outside. I would test it. When to balances. You know, I hate some of those old windows where if I open 3 in a row and the balance springs pop off on all of them, I can tell the client that I expect it to be a problem on all of them, but does that justify not inspecting it? I think what I might do is say that it's pretty obvious that these windows are going to have this problem. And you might say that I'm not going to keep inspecting them, but that sort of puts the burden on them to follow up. You just have to decide that. When I have springs that pop off on window after window after window, I still tend to inspect them. And then I can help the client understand that this is not just 1 or 2, it's all of them. But I do hate that. It's a pain.
Okay, Clay, when you complete this slide, we're ready for a 10-minute break.
Okay, let me see what the question is. My 2 cents. Okay, I'll read it. I assume everybody can see the Q&As, but there is a difference between not testing because of damage observed and not testing because you don't want to risk any damage. The second is a departure and the first is a defect. So if you're looking at it and you say, I just don't want to risk it, I don't want to risk that resetting, you, I think, are not following the SOP. But if you see damage to the pipe and you say, this is the reason I'm not testing it, you can justify that, only if you can justify that. I have not tested valves only under certain conditions, those I've described. When it's older than 10 years, I'm willing to not test it because at that point it's past the warranty. It's unlikely it's ever been tested, and you can usually find something else to justify it. When the temperature is above 70, does that not mean turning on furnace to check the burners? That applies to heat pumps, not just to a gas furnace. You can test a gas furnace. You can't test the heat pump if it's over 70. Discussion on chapter 2. What kind of inspection features do you provide? Features. What do you provide beyond the scope of TREC license? We'll answer the next part in a second, but what have we got? What are some things you do? Inspection, what do you do in your inspection that is outside the scope of TREC's license? We have termite. That's a separate license. Good. Okay, I see a question at the top. I want to answer that first. When you depart, what is a satisfactory time frame for notifying the client that you have departed? Immediately. You're supposed to notify them immediately. And if it's something that you plan to depart from regardless, you need to tell them the first time you talk to them. So if I come up to a roof, if I come up to the house and I say I can't get on the roof, I need to tell the client immediately I can't get on the roof, because the theoretical option that client has is to say, well, stop right now. I want to get somebody that can go on the roof. Jim says the departure provision is helpful when there's a cause. That departure provision protects you. You just need to be able to say why you departed. What was the reason? Thermal imaging when it's appropriate. You know, the thermal imager is not magic. It is a wonderful tool, but it is not a substitute for you doing a good inspection. Foundation elevation survey. The inspection of a foundation isn't, the TREC evaluation of foundation doesn't require that you do elevations. And in fact, I don't do it. I've done it before. I don't want that to be a part of my inspection. Let me put it that way. But I'd be happy to discuss it as something else. Let's see. Septic systems, okay. Sewer scope, we'll talk about that. All right, Jim, sidewalk in the right of way must be handicap accessible. Jim is a ADA certified inspector. I think that's going to get way beyond anything that we're going to do, because TREC actually is about the house, the structure, and excludes flat work and excludes fences and excludes any of those things that might be ADA. I do a lot of dishes. Thank you very much, Ken. Mold. Have a comment that says, I stay pretty close to the standards of practice. You know what? That keeps you out of trouble. This is what I was hired to do. This is what I've done. And this is the way I've done it. That you can't go far. And the inspection itself is pretty thorough if you just do that. Water quality, IR scans, missing insulation and exterior walls. I'm sitting here trying to read, but Brenda's marking these as answered, and I'm trying to keep track of where these are moving to. Recently did an inspection, and there was a previous inspection done. The other report indicated they had detected high CO levels at the gas stovetop. I told them that was beyond the scope, so I couldn't determine it. Well, first and foremost, CO detection equipment is considered specialized equipment that you're not required to have. So you're not in a position, you're not required to have that. You're not required to test that. And the other problem I would have following up on that is I would want to know when that piece of equipment was calibrated and whether they tested it following standard, whether they followed instructions from the manufacturer on how to use that. CompuLevel for floor elevations, wells and water conditions. Okay. Those are well, water, septic, things like that, water quality, all is a part of the optional conditions. Good answers. Duct routing according to Manual D guidelines. That seems to me a lot of work. I don't know that I'd be qualified to do that without spending quite a bit of time. Septic is covered under the standards of practice. That is, I'm going to say yes, septic is covered under standards of practice, but it does not go near as far as it should for inspecting a septic system. So I'm not going to follow the standards of practice for septic systems and tell my client that I have inspected that system the way it should be.
And Clay, one thing on some of these systems and methods that they're talking about optional stuff, TREC requires them to be competent in that. So there's got to be some type of training or knowledge to go along with doing those type of inspections or using that type of equipment.
Yeah. Water hardness testing of softeners, you just water quality, you know. When I see a water treatment system, I exclude it and say the only thing I have done is make sure water comes out the other end. I'm not doing anything about the water quality, and I can't tell you if that's working the way it's designed to work because I have no information from the manufacturer on how it should work. As a professional inspector, would one need additional training to do deck inspections as a single system? Remember when there were a lot of changes made to the standards of practice, I think it was back in 2008, and the discussion was that the standards were transitioning to a performance-based inspection. So the discussion then, or the expectation then, is that you're inspecting the deck to see if it's functional when you're there. It's not wobbling, it's standing up, things like that. But I think when you're doing a deck inspection where failure of the deck could cause personal injury or death, I would say that you need to know more than simply it's standing. Now, there are a lot of classes that you can take. You don't have to be a certified deck inspector, not that I know there is such a thing. But yeah, if people are going to stand on that deck, I think you should really understand decking, or you should have a disclaimer that says, here's what I looked at. I can't tell you if it's going to hold up to weight. I can't tell you if it's going to hold up to wind. All I can do is say right now, as I look at it, it's functional. You'll be able to tell that steps are loose, that rails are loose, that boards are loose. But then you get into how durable will it be? Is there a low path to ground, or is everything being held up by nails and prayer? So additional education is important, I believe, when you're doing decks. And Simpson Strong Type, InterNACHI has some great courses on decks. So I think I'm going to say you should get additional training, but it isn't absolutely necessary for the TREC SOP. If it's high in the air, you better be thinking about disclaimers. Zip level probe. Well, that's still, you're talking about elevations. It's not required. That's special equipment. You're not required to use special equipment. It is a service that's above and beyond the TREC inspection. You're certainly able to do it, and you could do it for more money, but you're also going to spend more time. Spa inspections. Okay, I'm going to make an assumption that you're talking about spas outdoors. If it's an indoor piece of equipment, the standards of practice calls that a hydro massage therapy tub, and there is an SOP for that. If you're talking about spa inspections, as I said, outdoors, that's spas and pools, or pools and spas. And yes, I would say that you ought to have more training and certifications. ICC now has pool and spa code, and there are other organizations that have certifications. I don't believe that you should try to do a pool inspection unless you have some of those, and then I'm throwing spas in there with that. And that's because, first, the money involved, and second, the danger involved. Now, if you're not doing a pool or spa inspection, you should still be looking at things like safety and electrical. Those aren't excluded. Manufactured home inspections. There are special requirements and rules with regard to manufactured homes. If you're doing an inspection on those, you need to disclaim those unless you are capable of doing it. So you're not necessarily looking at how well the manufactured home is anchored, and that is a requirement that they be anchored in a certain way. So if you're not inspecting that, disclaim it. But the foundation of it is, what is it sitting on, and is it stable, and things like that. Electrical. You can do a manufactured home to the standards with the standards of practice. You just need to be very careful that you don't imply that you've inspected everything with regard to tie downs. FEMA inspection. It's got nothing to do with the TREC SOP. and it's done for a different reason, but that is something that you could do. Adam made a comment about tie downs require a PE, an engineer. How does the ICC B1 differ from our profession as inspectors? International Code Council, IRC, section or the B1 certification is it would be that you've passed a test showing that you have an understanding of the structural system in the IRC. And that would be sections 1 through, I think, 11, where you go through the administrative, the safety, the foundation, walls, roof, all the way up through energy. If you have that certification, it would imply that you are more than simply licensed, that you have qualifications and training above the simple licensing. I would want to make sure that you had a B1 certification before you start doing pre-pour and before you start doing open frame inspections. I think that's the safe thing to do, to make sure that you are qualified with more than a TREC license. Commercial buildings. TREC has the TREC SOP has absolutely nothing to do with commercial inspections. If you're doing a commercial inspection, the question then becomes, what is the standard of practice? And there is an, I don't have it memorized, there is an ASTM standard for commercial inspections. InterNACHI has some commercial classes. They also have a book that pretty much follows the ASTM standard for commercial inspections. So if you're doing those, I would make 2 comments. You need to make absolutely sure that you know what the SOP you're following is so that you can defend your findings. And second, you need to make sure that your E&O insurance covers that. A comment from another inspector when we were doing some follow-up, your E&O insurance just almost absolutely does not cover any restaurants. So if you're doing, even if you are a commercial certification and you're doing something that has restaurant equipment, your E&O is not covering that. You need to be very careful. TREC allows home inspection to do commercial inspection of building up to 5K square foot. You have to tell me more about that. The TREC SOP is about residential. It's 1 to 4 property, 1 to 4 units. It's not got anything to do with commercial. Okay. It's a lot of things that you can do. Comment from another is a lot of software has commercial inspection additions. That would make it easy to create a report. I'm simply saying that you need to make sure that you can present yourself as qualified to do that. Pros and cons of performing these. Pro would be money. Con is more liability. Anybody out there see more than that? Is money versus liability, I think, is pretty much it. If you can do that, if you do the higher level inspections, it might attract more business. You could present yourself as a inspector performing higher level, so it would be marketing. It might be a pro in marketing, but that's only to get more money. So I think it comes back to money and liability. The 1 to 4 units allow us to inspect apartments, townhomes, and condos. Well, again, I mentioned that condos to me are not 1 to 4 family. So if you're presenting the 1 to 4, or if you're presenting apartments and townhomes as commercial, it's considered residential unless the townhome would have more than 4 units. And apartments, if you're truly speaking about apartments, yeah, that's commercial, but that's also more than 1 to 4 and would be outside the standards of practice scope. So again, it depends how you're presenting that. Okay, there's a, this is straight from the book. The inspector should verify which portions of a multifamily unit are common elements that the unit is responsible for versus elements that the client is responsible for. I disagree. I wholeheartedly disagree. I am not responsible for finding out from that association or from management or from the seller or from anybody who's responsible for what. I'm responsible for inspecting the house. So I'm not going to go in there and say they're responsible for the roof, they're responsible for the exterior, they're responsible for the termite activity, they're responsible for. But I certainly will say to my client, you should find out who's responsible for these components. I think that should be removed. I'm not responsible, and I'm not going to take responsibility. Comment made is we don't have access to the bylaws. It's exactly what I'm saying. I'm not doing any research. Jim Sutherland in the chat, I'm sorry, the Q&A, he essentially supported what I say. You need to be able to document your qualifications before you do commercial or anything that you're not qualified. And Brian, good comment. We're not qualified to provide legal advice. In fact, we're prohibited from providing legal advice. So if TREC is listening in, I think this needs to come out. There's a comment, do we need to check in from time to time or just at the end? I assume that is referring to the fact that you're not here in person and we need to know that you're in class. So I'm sorry, I was about to be smart aleck. So I'll just skip that and say there will be a test at the end and you will have to respond to the test questions through the chat box. So yes, you need to be here for that.
Clay, if I can inject something here for everyone that's online with us, the Zoom program webinar allows us to see how many minutes you actually attended the class, and you know, if you were live or not. So I mean, it goes into quite a bit of detail. So we are able to monitor that, and you have to attend the entire class to get the credit. I know we had a class recently on Zoom, and several people, when we go in and analyze it after the class has ended, we found that they didn't stay the whole time. Unfortunately, they won't get credit if you don't stay the entire time. So yeah, you need to stay logged in. We need to know that you're there.
A question is, best practice is not a requirement. If it is presented as the best practice, it is not a requirement. It is, if there's something that's a requirement, it says you are required. This is whoever wrote this document is suggesting that is the best practice, but I think we've pretty much shot that down. Routine departure. You are required to notify a client or prospective client at the first contact if it's something that you don't inspect, routinely don't inspect. Probably the most common of that is the roof. If you never go on the roof, then when somebody calls you and asks for pricing, you need to say, you know, here's the price. I do not go on the roof. They need to be able to pick somebody that will go on the roof if that's important to them. I don't know anybody that doesn't open electrical panel boxes, but that might be another one that stands out. What are some others that you can think of other than the routine departure? What is a routine departure from you? I guess it would be not testing the T&P valve on a water heater. That would be routine for some of you. Crawl space, small crawl space. Yeah, there's many people that don't do that. Crawl space, crawl space, crawl space. Crawl spaces depend entirely on how much I ate that morning, whether I think I'm going to fit under there or not. In the SOP, it does not specifically state what roof slopes may be too steep to walk. How do you determine what's too steep? I look at it. I'm not being smart aleck there. First thing I do is I look at it. If it's 2 stories all the way around and I can't get to it, then it's obvious. I'm required to carry a ladder that will get me to the first story. And if I look at another one and I think, wow, that's just too steep. Remember, you're supposed to tell how you inspected it. And there are a lot of things you can do from the ground with binoculars, from upper floors where you can look out over the roof, from balconies where you can look out over the roof, from a ladder, from the roof itself. However you do it. If you're going to simply, or if you're not going to go on the roof, I would encourage you to put the ladder up against the roof. And if you go up there, I've done this, I go to the top of the ladder and I put my foot on the roof and I look back and tell the client, I'm sorry, that's just too steep. And I've never had one say, no, I think you can get up there. I also make a practice of taking a photograph of my hand on that roof. Usually I'll have a watch or a ring or a pen or something in my hand that I commonly use. And I have been asked about it in the past. And when somebody looked at the picture and said, how can you prove that's you? I just put my hand out there next to the picture and it had my watch, my ring, and my pen. And they said, enough said. And if it's wet, if it's an older roof where you don't know until you're there that the granules are very loose, you got it at the top of the ladder, you just run your hand over the roof and those start sliding off. You look in the gutter system and it's full of the granules. That's more unsafe and you'll just slide off. If a roof is too hot, if you find that the roof is just scorching hot, you put your weight on it, you're going to mar and damage that roof cover. So there are a lot of different rules, and I don't really know till I'm there. We have a person who notes that there's a pitch gauge available as an application for the roof that will tell you the pitch. I am not, I don't have to know a pitch at which I won't go up. I just have to know that I'm not going up for example, I've gone up some steep roofs because I could hold on to something as I went. So it isn't, the pitch alone isn't what makes the decision. Okay, I'm trying to read this one that's about commercial. So go ahead and get rid of the other two if you want, Brendan. Okay, regarding commercial inspections, it is being said that the classes offered as CEs by licensed TREC providers are not significant enough to begin inspecting commercially. I agree. The classes by TREC providers, well, okay, let me, it depends who the provider is. There are some providers out there that might be presenting classes for commercial. InterNACHI has classes to help you inspect for commercial. I would suggest that if you're going to inspect for commercial, that you also have the commercial certification from ICC. You saw the comment on the Q&A a little while ago. Somebody said that the attorneys, while he was there in court, said, what are your qualifications? And I think if you simply say, I took an 8-hour class, that's not going to hold as much weight as I have the ICC certification for building. What if the builder says that we cannot go on the roof or open the electric panel? Your client doesn't own that house, the builder owns that house. And if they say you can't, then you can't, and you document that you didn't because the builder would not allow it. And then what you do is see if you can't talk that buyer into maybe hiring you to do that after the fact. But if the builder owns the property, they can prohibit you from doing that. 10-foot selfie stick from a top floor window, great. The drones, great. Do you find that cougar paws are good roof insurers? Everyone I've talked to said cougar paws are effective. Does anybody else have any comments about cougar paws? Somebody said all roof damaging. Are you saying that the cougar paws damage the roof? Saved me more than a few times. Well, I think everything I've heard people say that cougar paws are valuable. Okay, so clarifying, you're saying that cougar paws prevent you from damaging the roof. Some extra information about the value of smartphones and how they record information. Okay, Jim Heim made some comment here about rules to act and serve as an expert witness. Frankly, I would suggest that if you're not up on all of those rules, you can just step back and say you're not qualified. I don't consider myself qualified, and I'm commercial certified, and I have other certifications. Part of that is I'm not willing to sit up there and defend myself. But there are a lot of rules, and you've got to really be prepared to take some heat if you're going to present yourself as qualified. Cougar paws, all of that seems to be good for it. Okay. One comment made here is don't get the inspector cougar paws, get the better ones made for roofers. Okay. When you don't have to use the standard report form, you know, I think we went over that, but it's not a 1-to-4 dwelling building. So, and again, I said, in my opinion, that excludes condos, but I still do use the form and the standard on that. Single item inspections, you're going back for that re-inspect, or somebody says, I need somebody to just come and inspect the foundation. Phase inspections, FHA final inspections, things like that. Comment about Cooper cause damaging the roof. It seems to be when the roofs are hot and soft. But in my opinion, if it's hot and soft, you shouldn't be going up there anyway, regardless of the type of shoe you have. Has anyone used a hook and ladder for roof inspections? You can answer that, but let's keep going. Routine practice versus specific. I think we've already talked about that. If it's routine, you have to tell them immediately. And roof and water heater relief valves are two of the most common. Tell them the first time. I don't tell them until I'm there, because I haven't decided I will or will not test the water heater relief valve, or will or will not go on the roof until I'm there and see it. Does the fact that optional items are in the SOP imply that you're qualified? No, not to me. But I guess this is discussion, and I should have waited for you to post some comments. But if you take it to something like the irrigation system, I can run the irrigation system, but that by no means tests the backflow preventer. I simply say that it didn't stop it from working, it didn't leak, not broken, things like that. But I just test the irrigation system and exclude a complete test of the backflow preventer. Pool, again, we talked about their certifications. You really need to understand what you're inspecting on a pool. And by golly, you better make sure you don't flip a valve you're not sure what it does. I was accused of draining a pool, but I was able to document with photographs that I'm not the one that changed the valve position. It was the person that came to service the pool. He was after me. My photographs showed that when I walked away from the pool equipment, the valves were proper. Several days later, the homeowner of the unoccupied property came and the pool was empty. Take photographs. Well and septic, and again, those aren't some that I attempt to inspect. Inspection for a lender or investor. Well, if you have an investor buying the property, then it's going to be the SOP. Inspecting for a lender, they're looking to see if it meets their requirements as collateral, and they usually have some very specific requirements for that. There's a question about, I believe we can delete the optional item on my report. We'll talk about this afternoon. Jim made a comment, last disciplinary action on a pool inspection was $1,000 fine and additional 16 hours of continuing education above and beyond the 32 hours for the next renewal. I don't remember that disciplinary action. I'd like to read that. If you can point me to it. There are requirements for inspecting a pool according to the standards of practice, but you've got to keep in mind that's an expensive thing to screw up. Be careful. Doesn't SOP say something about inspection for entity that buys, sells real estate regularly, not subject to SOP? Not that I know of. If there's a buy or sell transaction of a substantially completed house, 1 to 4 properties, it's subject to the SOP. Again, if you think there's something about that, point it out to me and I'll follow up on it. Comment from Shannon that a drone inspection does not fulfill the SOP. It says inspect the roof covering materials from the surface. However, the departure allows you not to go up there. So the drone, to me, Shannon, is no different than binoculars from the ground. It's just another way. It's no different than a camera on a stick. It's no different from some of the other things. I agree it doesn't fulfill the SOP except as a departure. It's more than not inspecting. You're still required to inspect it if you can't walk it. Okay, if the inspector uses commercially available software to generate reports, whose responsibility is it to make sure that it is accurate? Well, you know what? That's just kind of real simple. That is you. You're responsible for your report. Therefore, you're responsible for making sure the report is accurate. And every time the report changes, there are the software companies that don't update it and the inspector who doesn't update it if it's available to them. You are responsible. Not walk on roof. We've talked it through, I think. Steep, wet, icy, too high, fragile roof covering. That would be tile, that would be clay, that would be metal if you're not careful. Comment in the study guide is that the rain gutters, if rain gutters surround the entirety of the eave and there's no place for you to put a ladder against it unless you're against the roof cover, you're not required to. I don't think that's a valid reason, because if the gutter's not there and you put the ladder against the roof, then what you're damaging is the shingle itself, since the shingle should hang over the drip edge about 1/2 inch to 3/4 of an inch. So I'd rather lean it against the gutter than lean it against the roof. Now I do my best to make sure that I'm leaning the ladder against the gutter immediately at a fastener rather than between fasteners where it's going to bend. So I don't believe that is a valid answer, but the rest are absolutely. Can we add a table of content after the TREC intro? That will be this afternoon. Would you suggest using TREC report on the final phase inspection for the builder to close out his permit? Okay, for that question, I have to understand whether you're inspecting it for the builder or if you're inspecting it for the client. If you're inspecting for the client, you must use the form and you must use the SOP. If you're doing the inspection for a builder, you're going to have to depend on your contract with the builder for the type of inspection that you're doing. You wouldn't necessarily fall, I'd be very careful, you wouldn't necessarily fall under the TREC. You're having to show that your contract is with the builder, not as a TREC inspection, but as a third-party quality control inspection for the builder. Can you expound on that, Jim? Talking about a third party inspecting for the builder. Okay, Johnny, I think Jim is trying to address that, but I don't have enough information. Curtis, if an inspector with a disability departs from a crawl space, do you think that is reasonable? Absolutely. You just need to be able to tell the client beforehand. And I don't ever go to an inspection without knowing whether it's a crawl space. So if it's a crawl space, you simply tell them that you won't be entering that crawl space the first time you talk to them. We have a comment about check your PDFs periodically. I think you not only need to check your PDF, you need to check your library comments, you need to check form numbers, you need to check copyright dates. There's an awful lot of things that you need to check because you get in the habit of looking, you get in the habit of not looking at it. And you know what? I'm afraid that people do that with homes as well. They'll sort of forget to look at something. It goes on, and then all of a sudden you realize you haven't been looking at it, and you look at it then consistently, but sometimes you exclude something else. Okay, Jim is saying use the pre-published notification for the builder. So that goes back to, you're not doing that as a TREC inspection, you're doing it quality control for the builder, and you need to use whatever form the builder is providing, the builder is providing. That's not a TREC inspection. Oh, I see. Okay, thanks, Tim. That is still, well, see, if I'm not doing a TREC inspection and the form's not required, and there's a form for another entity, a builder has his own form, then I don't see why I have to include the notice, because it's not a TREC inspection. But that's okay. It's easier to put the notice in than to risk the disciplinary action. So if you're doing third-party inspection for the builder, not a TREC inspection, put the notice in. Even though I think it's, well, again, like I say, I don't think it's necessary because it's not a TREC inspection. And TREC isn't, doesn't have any authority over that inspection. Okay. This morning class is 4 hours, so I think you were just being smart aleck. Only if you're using a TREC form. You're not going to use a TREC form for builder third-party quality control, because it's the builder that's going to provide you a form to be used. My builder doesn't have a form. Better use that notice. Figure out what they're expecting you. Okay. Jim is pointing out that the notice was written so that a third party doesn't look at it and say it is a TREC inspection. I still get back to the whole thing. If I'm doing something for the builder, they're not, the form is not the TREC form, it's not a TREC inspection, but put the notice in there and it's just CYA. When is the new TREC report 7-6 coming out? We'll talk about that later. Okay, we're kind of behind here because I'm trying to answer some of this as we go. I hope it's of value to you. It's been some great questions. Penalty matrix. This is pretty much showing that if you don't do what you're supposed to do, you're going to pay a fine. The older the form, the more out of date the form is, the more that you're going to get fined. The last change was just in the promulgated section of the report, talking about the CSST. Duties and responsibilities. You must prove competence by completing the courses. The only ones that are tested are these two mandatory classes today. The rest aren't actually tested, though. If you take an InterNACHI course, they do some things to make sure you're paying attention and that you're listening and that you're studying before you keep going. Don't waste your time. If you're taking a course, take it to learn something. Experience. So that is pre-licensing or trying to get the qualifications to have a apprentice. That's to pass the exams to get your license. Must continue. That would be the continuing education, of which today is 8 hours of the 32 per renewal period, which is 2 years. Must report to TREC within 30 days. The change, addition, or termination of a DBA. I have said this every time I've taught this class, and today's Zoom meeting might be one that is the exception, but I have never had taught a class where somebody didn't come back to me after I encouraged them to check and find out that they did not have the DBA listed that they thought was listed. Go and check. Okay, changes to a company name, changes to contact information. You've moved, you've got rid of a phone, you got a new phone. New felony convictions. Oh gosh, I gotta update that. Or misdemeanors. Update your profile. That's what it comes down to. So everybody should check it. I don't want to skip these, but we've got a lot of things to go. It comes down to disclose, disclose, disclose. $2,000 administrative penalty. Do I have to report a suspended sentence? Unless you have it expunged, it's on your record and you have to report it. And you can't, having that expunged is a lot more difficult than you might think. Make sure you have legal representation to help you understand that and make sure it's completely off your record so that you don't think it's gone and get in trouble for not having reported it. If you have a sponsoring inspector and you no longer are sponsored by them, report it. If you are sponsoring an inspector and you are no longer sponsoring them, report it immediately. That's sponsoring. Okay. Indirect supervision and direct supervision. I've had people tell me different things, and when I say people, some of this has included people in the commission. Present on site. When I first learned this, I was told that it's not just present on site, it was the inspector had to be in the room with an apprentice. Now they just say present on site, which in theory means that that inspector could be in a different room from the apprentice. I don't have an apprentice. I don't intend to have an apprentice right now, but I would tell you to be very careful that you are taking complete responsibility for that. Thank you, Jim. Okay, just make sure you are able to offer all the advice and support you need to. Indirect supervision just simply means they don't have to be on site. You have to be available for phone calls. You have to be available for email, any of those things. Okay, you can delegate the supervision to somebody else, an inspector or another professional inspector who is qualified to sponsor, which means they have submitted all the documentation and been approved. But the sponsor is still the one that has the legal obligation. Consumer protection notice. You know what? That's just to tell the consumer what protection that they have. You have to provide the notice, and it has to talk about the inspector recovery fund. Remember, that's that form we showed a little while ago, and it's blurred behind me, but that's those pieces of paper hanging on my wall. I think that should be C. Okay, this is C1-2. The other one I showed you with the addition is 1.3. So there it is. There's that form. Readily noticeable location in place of business. It's behind me. It's on the wall. It's readily noticeable. And as soon as this is over, I'm going to move it to someplace else. Also required to put it on a link on your website. Readily noticeable place on the home page. And it must be labeled in 10-point font minimum. Everybody should check their website. Your website has to have that notice on the home page. And if you don't have a business and you don't have a website, you can do these things. Put it on a written contract, a brochure, or a bill or receipt. So if you don't have a website, and I suspect there are very few of those, there's still places that you have to post it to make sure that they get it. And we're not just talking about the verbiage. It should actually be attached as that form. And then we have this optional consumer notice. We'll talk about that this afternoon, because this is basically the promulgated report. Comment from inspector present is for flexibility if you have them conducting a special task, not micromanaging. I guess it depends. Just this goes back to the apprentice and on-site direct supervision. I guess it depends how new that person is and how capable they are. Even checking a receptacle, I might have a problem until I'm certain they're able to do it. We have one comment. Somebody just updated the profile. So I guess that would mean that this is another time that we do find that somebody has just recently updated and found they should. Does the new consumer notice need to be updated on the website? You don't have to have the notice there. You have to have a link to the notice. And unless TREC breaks the link, if they update the notice, you're covered. And this is me showing you that this information is available on this form. So we'll talk about that. Advertising. What's considered advertising? Your report, business cards, invoices, all of these things. Text messages, we've discussed a lot of times in the past. All of these are used to solicit business. Text message, if you're using text messages to solicit business, then yes, you have to treat that as advertising. That would mean to me that you're doing some sort of text message broadcasting trying to solicit business. If somebody texts me and says, how much would it cost? Do you have availability? I don't put my license number on there. I don't think I'm wrong because I'm not broadcasting that. I'm just responding. But when I start then by sending them inspection agreements or anything else, and I respond by email, all of that has the required information. You cannot use the TREC logo on anything. There is one version of the form that has that TREC logo on it. It did not show up as a part of the new form. There was not a new form. It was just one day that form did not have the logo. The next day it had the logo. But you can't use that on your business card, your letterhead. You can't use that on your website. You are not TREC. You must include your name and the assumed business name or the DBA and your license number. That is if you are a professional inspector. If you're not the professional, but the other two, you also have to include information on the sponsor, including name and the statement itself saying that you were sponsored. You can't be out there presenting yourself as anything other than what you are. So if you don't indicate you're a sponsor, then the implication is that you're a professional. So what's missing? License number. What's missing? License number. But something else is missing. You see that that's a real estate inspector who must be sponsored, and that information is not on there. This is the same stuff. You have to have that available on your website, social networking. I would guess that's something like Facebook. Your license number needs to be on someplace. Mine's on the profile. That's where it gives me an opportunity to put that there. Do inspectors have to put physical address on a website or cards? No. Isn't the license number requirement antiquated? No, I don't believe that the license number is antiquated. That license number gives an idea of how long you've been an inspector. Now, yes, somebody's got to be more educated about it than simply look at a number and say they've been doing it this long. But it's easier to look up a license number than it is to look up a name if you have problems spelling the name correctly. There are some out there that, I mean, you know, try to spell Sahagian real quick, right? Thank you, Sam, for being an example. It's a whole lot easier to look up the license number. I don't think it's an antiquated requirement. I have a comment that he's had home builders look him up. That's Daniel. Thank you, Daniel. You're not prohibited from receiving a fee or valuable consideration as long as it is not without the client's consent. I read that wrong. Hang on. No, you are prohibited without the client's consent. What's the rule regarding using nicknames? There is a agent, I'm making this up, the name up, but there's an agent that uses a nickname and the made up name is Booger. Okay, just because I can't think of anything else. That's all the advertisement ever says, the billboards say, the business cards say, but that is not found anywhere on the TREC website. So you have absolutely zero way of looking up that agent by the name they advertise on. So if you're using a nickname, I would suggest that you treat it as a DBA. There should be some way to find it. Now, when you get into the John or the Jonathans, the search can be tailored to look for S. Sahagian, Sam Sahagian, Samuel Sahagian. So I don't think that the nickname in and of itself is a problem unless it's something that has absolutely nothing to do with your true name and you can't find it otherwise. What is considered advertisement? We talked about that. It is what you're using to draw people to you. And there's the link to the form we talked about, not the form itself. If anyone thinks I'm going too fast, just tell me, but I'm trying to make up some times, and I think we've discussed most of this. Name, this is what should be included in your marketing, the name, license number, and the link to the notice. Okay. Ethics. What's the whole point of our job? We are protecting the consumer. Fraud and misrepresentation. Well, we've all had inspections where we think maybe the seller should have known it and is likely to have known it. And I would say that that is fraud. We also have misrepresentation, whether it's on purpose or unintentional. One of the things that bothers me the most is reading these disclosures, and they say that there is a new air conditioner. There's 3 components to the air conditioner, and they may have replaced one, but to them it's new. I've had them say new appliances, and the appliances were 4 years old because in their mind they were new. That's misrepresentation, and not necessarily an unethical misrepresentation, but we have out and out fraud. I had a seller that would not leave, and he sat in a rocker chair, and he rocked the entire time I was there. And then I realized what he was blocking was the return air. I asked him to move, and he just sort of slumped. I removed the return air filter and looked in the chase, and inside there was the tub, and the entire backside of the tub had corroded, and they had resurfaced the tub without doing anything else. He was hiding that. He knew it. It was recent. And I walked over to the return air chase on the other side of the house, and it was exactly the same thing. That was unethical. He knew it. He was trying to hide it, and he was trying to keep me from getting to it. 20 and 30 ounce cups made with my logo, shirt or cap, require the license number. I guess if I read the rule, it says the license number needs to be on your pins. It needs to be on your gifts. It needs to be on your caps and shirts. I don't see anything in the TREC rules that exclude those advertisements. So what we would come back is what is considered advertisement. Trying to get you to use your services. And then we have another one. Daniel said he just asked, and the answer is yes. So there we go. Inspectors must have integrity beyond that of a person involved in ordinary commerce. You are going into a person's home that you don't own, and you frankly weren't invited. You were allowed in that home. I've said before in some of these that every home I've ever been into has a camera in it. Absolutely every home. That's the way I treat it. That means that you're not just treating the seller of that property, but you have to treat the buyer, your client, the same way, because they need to know that you've got no agenda other than doing a good inspection for that client. Wearing a company shirt with name logo, which TREC license number gets sewn on the shirt? Well, I would say it is the license number of the person wearing the shirt. But if it's a company shirt and there's more than one inspector at that company, it would have to be the principal. Well, no, I guess it could be the principal, or everybody's going to have custom shirts. Invest in some rubber stamps, I guess. Conduct your business with a high standard of professionalism. Maintain independence from outside influence, which would be people who want you to report it their way to make it easier to sell or close, whether it's for money or anything else. Fair and objective. Do this in the eyes of your clients and the public. I have had clients and agents ask me about various reports, and I've seen some things that I just didn't like and didn't seem very professional. And that report that you generate reflects on the industry, how people act, how people talk, how they treat agents. Don't badmouth the agents, don't badmouth the seller, don't badmouth other inspectors publicly, because the whole inspection industry then is seen through your eyes, and it's kind of, it hurts us right here. It hurts us here. Place the interest of the client before your own personal interest. You're there for one reason, and it's to protect the client. Anything you're doing so that you stand to gain isn't for your client, it's for yourself. Seek to improve your knowledge. That's what these continuing education classes are. And it's not just the 8 hours today. If you have a question about pools, take classes. If you're thinking about your lack of knowledge about septic systems, take classes. That doesn't mean you have to present yourself as certified, not that a septic inspection requires somebody that's certified, but increase your knowledge about that so that you can be smarter about it. Even if that intelligence, even if that knowledge now allows you to say, you know what, I don't know enough. Call somebody else. Help the public understand the need and value for home inspections. You do a good job, you're going to show somebody that there's value. Client is the buyer or seller. This is the definition that was added. Remember, in the very beginning, we talked about updates. So now this is the definition. It is the buyer or the seller. It is not the person who paid for it. Expands that definition. We have about 30 minutes left, and we've got about 100 slides left. And some of this we've discussed, and that's why I'm moving on. I'll stop if I see something you really need. Okay, prohibited from discussing or disclosing inspection results or client information without prior approval from the client. My inspection agreement that is delivered with them to have at least 24 hours to follow up on has a place for them to sign, initial that says they understand that I can discuss this with, and it says agent. But I always make a point in dealing with the client. If they say, I want to send it to the builder, they want me to send it to the builder. I said, I will send it to you and you can send it to the builder. And by doing it that way, you have an opportunity to review it and make sure you want to pass on all of that information. I've had sellers agents that show up at the end and sit down and say, okay, tell us what you found. I've had the seller there and I've had to say, listen, while you're both here, let me explain that I am prohibited from giving you this information. And the client says, that's okay, let them be here. I make a note. Here's what happened. Here's the time it happened. This person said this to me in front of that person. Document that that's what went on. I haven't been smart enough about it to get them to sign something, but I make clear that this is perhaps hurting their opportunity to negotiate. You should be independent from outside influence or interests. It is probably most often that would be from the agent who stands to gain from the close, or the seller who also stands to gain from the sale. And there might be cases that either one of those would encourage you to ignore something. You need to follow the standards of practice that will protect you from those outside influences if you do what you're required to do. It says to report it, you report it. It doesn't matter what either party wants you to report or not. You follow the standards of practice. That is your defense. Person paying for the inspection may not. This is discussion. We've kind of talked about it, but a parent that is maybe paying for the inspection because their children are buying the house and they just want to help. A realtor paying for the inspection. Sometimes that happens when somebody's just being nice, or maybe somebody is doing it to help move it along. Kind of hard to say. Somebody complains to you about another inspector who missed something. What do? Well, I tell them, have you called that inspector? And if it's something really egregious, I say, you know, there's a way to report them for that. I try my best not to get involved in it, but if it's somebody I know, I have called the inspector and said, hey, this person said you missed this. You might just want to follow up, call them, check your notes, see if you missed it, see if you want to defend it, but be aware that somebody is saying that about you. Now what you're doing is telling that inspector, just be aware, protect yourself, and maybe that also serves to say, hey, you dummy, you missed it. What can you do after the inspection? I've had quite a bit of luck, and especially if the client can't be there. I like my client be there during the inspection. If they're not there, I call the next day. Did you receive it? Did you understand it? You weren't there for the inspection, and I couldn't tell you some of those things. Is there anything you want to ask or follow up on? If there was any concern during the inspection where they were expressed some specific concern, I might call them and say, now that you have the report, you see what I've written, and I know you were concerned about it yesterday. Does this answer the question? A lot of times I'll send them links or other information and make sure they got that and that answered the question. There is a Q&A comment that somebody created an authorization and release form for clients to sign prior to releasing any information. That is in my inspection agreement, but it sounds like you might have a form that you would use on site. Maybe that's excellent. So it doesn't substitute for the inspection agreement that covers so much more, but maybe there's a single document that you could carry in at the last minute. Then you can have them sign that to give you permission to talk in front of the seller. Do I try to get a copy of the seller's disclosure notice? If they hand it to me, I say, thank you very much. I will look at this at the end of the inspection so that you know that I'm not simply taking something that was written. You know that I'm doing a complete inspection. And when I pull that disclosure out, it's very, very, very rare that they disclosed something that I haven't found. So the answer is no, I don't try to get that information. I take it if it's offered, but I don't try to find it. Okay, this is basically saying that these are people that might be trying to enter the property while you are there and have opened it and are the person who has responsibility over that access. Pest control company, a lot of times we're the ones that coordinate that and bring them out with us. I would imagine that if you have a company that you refer, that there's going to be some knowledge and expectation of their integrity. Home security companies, contractors for estimates. Probably one that stands out is family members and neighbors and half-step neighbor-in-laws that want to come with the buyer, your client, to take a look at that property that's being bought. And I just have to say, sometimes you need to stay here. You can't let those kids run around. You need to be careful. All sorts of things. Couple of comments there. I like that, Mark. Mark says he tells them that he charges by head count. So you can bring anybody you want, $100 a head, payable to you. Jim says an inspector was recorded this week and the listing agent called the inspector about his comments. The seller and listing agent weren't happy. I would report that to TREC. I would do that immediately. I don't know of that, but I'd report it. If they have access, they can come in. He locks the door when he's inspecting. I think we talked about this, pros and cons of having the homeowner present. What have you got? Well, pros, they're available to answer questions. Doesn't mean they're not lying about it. But there you have it. And cons, you have them looking over your shoulder, asking what you're doing, what you're writing, why, and they start arguing with you about what's right or wrong. The con here is to the homeowner, no con to your client, but now the homeowner puts themselves in a position of having to disclose things that they're now aware of if that sale fails. And then follow up on that other one. Yes, that's a specific form he carries just in case he wants to or needs to have the client give permission to talk to somebody. May make the client uncomfortable. That's probably the biggest one I see. The client wants to ask me questions, and we've got that homeowner hanging around. I find that they just don't answer the question as well as they could. When I make a point of telling the client that the seller really shouldn't be there and I can't say things in front of them, almost all of the time the seller says, I'll go away. A couple of times the homeowner is the buyer, my client, has said, that's okay, they can stay. That's when that form should come into play. If a buyer wants to look at the property while I'm inspecting, they must have their agent present to babysit. I have a job to do and it is not keeping up with the buyer. I want my buyer with me. I tell that buyer, you follow me, I'm going to talk to you, I'm telling you what I'm looking at. So I'm babysitting that buyer at my choice, because I have found that client, my buyer, is much more able to understand the report and there are less questions. And frankly, I get better performance reviews. I get good comments from them because they understand. Any liability safety concerns if the client is present? Absolutely. Absolutely. If something happens, if something's damaged, the seller can hold you accountable and the client can hold you accountable, saying, well, you should have been able to stop me from stepping through that ceiling. I give my client a notepad. I assume that's a notepad, and ask them to put their questions there. That all comes down to your methods. Mine is to have the client there and talk to them. I find that it takes me the same amount of time to do the inspection and then go over the findings and have to go back and point the things out as it does to have them with me and talk about what I'm looking at. It all comes down to your style. Clients present. You can answer the questions as they occur. The cons. They want to follow you in the roof and attic, even if you discourage them. I finally have to get to the point where I say, no, you are not allowed to come up here in the attic with me. Yes, I had a client go through the ceiling. He followed me up. He was about to step. I grabbed his arms and said, stop. Let's walk around each other. If you're going to be up here, I want you to stand right here. I turned around to record some information and he stepped off. We've talked about that. It's independence, relying on your knowledge. This is straight out of the book about outside influence. Many buyers don't really understand that we're there to give them information about the condition of the house today. We have them that think we are there to give them something to negotiate for, or we are there to tell them that the air conditioner is going to fail in 8 months, 7 days, and 4 hours. They don't necessarily understand that we can't see through walls. They expect we could see through walls. In some of the classrooms, I have a crystal ball on the shelf back here behind the form. Clients think we have that crystal ball and know how to use it. I've had clients with me and an agent there, and I point something out that I consider critical, and the agent says, "Oh, don't worry about it. I've got a guy that can fix that. Oh, don't worry about it. The warranty will cover it." We know that both of those things are extremely inaccurate. So don't let that agent influence your buyer. We have a comment that he encourages them to come to the attic when safe, and any or maintenance items like filters, relief valves, and water heaters. Absolutely correct. I do that myself, and I say to the client, wait here until I see if it's safe, because there are things. I'm very diligent about telling new construction builders, listen, you put the filter up there, you put the water up here, water heater up here, and you put the ventilation system up here. All of those are to be serviced by the homeowner. So you better make sure that there's a safe way to get to it. Comment about taking pictures of serial numbers in case appliances get switched out. That happened to me one time years and years ago. But I take pictures of every manufacturer label on something that's a piece of equipment like that. So that's kitchen appliances, water heater, HVAC systems, ventilation systems, everything that could be swapped out like that. And yes, I've had that happen to me. Okay, this comes up an awful lot. So you have a phone call, and then somebody says, "Hey, I am with," and they name the agency, and says, "We're working on a project." I can't tell you how many times I've heard, "We're working on a project," and what it all comes down to is they're creating this brochure, and they will allow you to be on this brochure for the small cost of. And don't worry, only 2 inspectors are going to be allowed to be on that list. That is not allowable. You cannot pay to be on a list. That is an exclusive list. If the number of inspectors is unlimited, then that's a different situation. But you can't pay for the privilege of being on a list. I think that's pretty straightforward, but it happens all the time. And when they tell me they have a special project, I say that's against the law, and it stuns them every single time. Some have preferred inspections. So what's the pros and cons of that, and to whom? Well, the agents can say, you know, these are some I've used that are competent, because I've used some that I don't consider competent. They usually will offer the best opinion of the good inspector, but we know that they also, those that are being unethical, might simply say, here's a good one to use. I was talking to a new inspector. He's only been licensed about a month. And so he was approaching agents and trying to get business. And the question the agent asked was, how many pages is your report? You got a lot of agents out there that want the simplest, shortest, most uncomplicated, and hopefully least information on that report for their client. I'm going to give the best report I can give for my client without regard to that. If they don't want to use me because I have a long report or have information they don't consider relevant, as long as my client appreciates the report, I'm good. It can be abused. This is talking about the personal choices, not based on competency. It's based on how short that report is, or maybe that they can't and don't find those things that can slow down a closing. Pay to play is what that's most often called. I'm going to skip. We've talked about that. What recourse? Well, the recourse is if somebody has this pay to play and they won't let you play if you don't pay, you can report them to TREC, and you should. I tell you what, the most exciting point in my life was, as an inspector, was when I realized I was getting more business from referrals than from inspectors. I'm sorry, agents. When I realized that I'd been doing a good enough job long enough that it was the client base providing me my next job, that was exciting. What keeps the broker from asking for money? Well, it really kind of comes down to TREC rules, so you can't. Hot topics, okay. We know what CSST is. Daniel, you can sponsor events. We've talked about this for years and years and years. It has simply come down to the TREC has recognized that it is a problem and has put it on the consumer notice and has put it into the form and the preamble. It's all about bonding and grounding as, well, no, it's not all about that. We have a material that's considered to be safer if it's grounded and bonded or bonded. It doesn't mean it's safe, it means it's safer. And the standards of practice don't require you to determine if it's present, because you can't always determine it, but if it is present, you should disclose it. Hydrostatic testing. When I was doing a plumbing class, I had someone say that the discussion I had about hydrostatic testing was wrong, but hydrostatic means that it's static. There's no pressure. It's just letting water stand. The problem is that it has resulted in damage. So the thought being that the testing pressure is higher than the normal operating pressure, causing system damage. Again, I disagree with that, but it doesn't matter. You're not allowed to do hydrostatic testing because you're not a plumber. It is not mandatory to do that. The law says that the hydrostatic test can only be done by a licensed plumber. And if in fact there's going to be hydrostatic testing, the seller has to sign a separate authorization. So you as an inspector can't do hydrostatic testing. If there's to be hydrostatic testing done, it has to be done by a plumber, and the seller has to authorize that. And I won't download the form, but there it is. I've not heard of this, but TREC has said some agents may try to coerce inspector into performing a hydrostatic test. You're not qualified, don't do it. If you have one of those address you, teach you, treat you that way, then report it. All right. Change in 2020. Notice, please, that this is not about the hydrostatic test. This is about a sewer scope inspection, which would be taking that downstream side of the plumbing. It would be outside the house, basically, and you would be going through the sewer, which is from the house to the city mains, looking for damage to those pipes, whether it's from age, ground movement, trees, roots, whatever. As of August 2020, you now as an inspector could do that. And the state of Texas plumbing examiners aren't going to hold you. They say you can do it. But the real comment here is, if you do that, you still have a responsibility to do it competently. So the SOP doesn't cover that. And you're specifically exempted from using specialized equipment or looking for defects that are buried. So if you're doing a sewer line inspection, it is outside the scope of the SOP. It would be one of those above and beyond, and there's no standard of practice for it. So you need to figure out what the basis of your inspection is. I just looked, I used this camera, this equipment, I looked in there and I didn't see anything. You might, okay, I'm getting notes here that I don't think we're going to skip anything, but we need to do the test. Now, we need to talk about providing an opinion of the foundation. I still see a lot of people that aren't really doing an opinion. They'll say something like, I see some cracks, you need to get an engineer. That's not an opinion. You need to say, my opinion is it's functional. My opinion is it's not functional. Now, I think you need to get an engineer, or you know what? I think there's a lot of cracks, and even though I may think it's functional, I think you need to get an engineer. Don't pretend to be an engineer. You're not saying, here's why it cracked. Here's why it's not functional. Here's what you should do to repair it. You're simply saying, my opinion of the foundation is based on, and then tell them what you see. Ended up rushing through some of that this morning. We have gone through a lot of that before. There was some new stuff. I don't think we missed anything. I hope you don't feel that I took away anything by answering those questions. That's what's fun about these is getting the questions and the feedback. So we're talking about the form. Now this is, it's been several years that we've focused on the form, but they are, I believe, I understand that the inspector committee is developing a new PowerPoint presentation. I look forward to seeing it. Until then, we're going to talk about this report form. Now, I will note that there are some draft revisions to the SOP. And just like I told you this morning, you need to go out there and look for those. You can go to TREC's website and see their meetings, the agendas, and the documentation that came from it. You'll see the drafts. We're not going to talk about that because today and now this is the form that we've got. I don't want to mislead anybody by trying to teach what's not even been adopted yet, but I would encourage you to go look at the draft of the SOP and the draft of the form. All right, the provider number 10026, that is InterNACHI, and the course number 37033. You have the form you see over there, and it is 7.5. We'll address that several times, but right now, just understand that. What are our objectives? We're going to look at the form in detail, departure provisions, some of the updates to the standards of practice, and then just look at some of the individual systems that are a part of the form and how you might fill it in and how you might work with it. REI 7.5. I've told everyone before, I've tried to collect all the forms. I've gotten some very old versions that are kind of neat to see the transition to where we are now. But this is 7.5 and you need to check. And if you're using anything other than this one, you're using the wrong form. We're going to talk about the rules pertaining to the form. We're going to talk about some of the key components, how to fill out the form, what can be added and what cannot be added. The key components, I think, is one of the best things that we can talk about here, but we'll just take them one at a time. For each inspection, the inspector shall prepare a written report. We talked this morning about what, when we were required to use the report. It was for the 1-4 families. It was for a sales transaction, whether you're doing it for the buyer or whether you're doing it for the seller. It must be in written format. Now, in the occupancy code, it describes an inspection or defines an inspection, and it doesn't say it has to be written. But under the TAC, section 535222, it's specific to preparation of a written inspection form. So when the standards apply, it must be a written form. And this is one of the changes. We talked about it in some detail this morning. You have to do it, you have to deliver it within 2 days. This is actually worded wrong. Deliver the report within 2 days, assuming that you've received payment. So you don't get the payment and have 2 more days. And then the exception is if there's an agreement in writing that allows something else. Friday and Saturday, Saturday and Sunday, those are not excluded. These are calendar days. The assumption is that you can write a report on a Saturday. What about a cosmetic inspection for the final walk? Again, I think I need to know more information about that. Have you already done a final inspection and you're just with the client, or you're looking for cosmetics? If you're doing an inspection to the standards of practice, then you have to have a written report. So Daniel, if you can give a little bit more information about that, I could probably answer it better. The report shall include the client's name, the name and license number of each inspector. Now, you'll notice that this isn't just saying supervising real estate inspector, sponsoring inspector. It's saying each inspector. I have done houses that were large enough that it was worth subcontracting with another inspector to come out there and help me. That name has to be on the report, and license number has to be on the report as well. So if you only have the one inspector, that's all that's necessary. If you have a second inspector, or a sponsoring inspector, I should say, that name is necessary along with the license number. You know, I wrote this, or I prepared this some years ago, and I just looked down there and see the inspector's name. I'm pretty impressed with myself. That's a funny name. Okay, then if you have a co-inspector, you'll notice down there it's about the same thing except a sponsor, and over here the number here it's excluding the fact that it's a sponsor. There's not a separate line. So that's the way that I would recommend that you do it. Just the name of the inspector, and then I would even say something about this as a sponsor. There's not, you can modify it to add a line or take away the sponsoring if you don't have, if it is just a co-inspector. I think you could get away with modifying that, but the rules actually say you can't. Do something so that you know who is who. Michael, if you have a new inspector come and follow you around, I think you need to have the name on there. You need to, no, not here. You wouldn't have it here, but I would document someplace in that other information provided by the inspector. They are not an inspector, so they don't have to be listed with a license number, but I would certainly document someplace that they're on site with you. The address or unique description of the property on each page of the report. Well, after a while, you get so many different inspections in your files that you've got to come up. Okay, I don't know why that page is there. That's a duplication of the other one, but here we go. Unique descriptions. Not only do I use this as the description to go on each page, this is the various ways that you could use to create a file name. My first one, the first one in this bullet list is what I use. The last name of the client and the property address. I can pretty much find any client I've ever done an inspection for that way. Others, and this is, I'm pulling these from reports I've seen. They have the year, month, date, last name, first name, just the property address, the report number, assuming they have some way that they create that number. You're just going to have to pick and choose. I can sort by last name and I can search for address. So that has just worked well for me. You can put that in a number of different locations. The way the promulgated report is prepared and downloaded has the report identification on the left-hand side. Because of the number of years I spent writing documents and writing reports and writing audits and everything else, I put it on the right-hand side. And the reason for that is that normally you staple or bind it on the left-hand side, which makes that get a little complicated to read when you don't have the movement. So I do everything on the right-hand side for that. Perfectly acceptable. We could do it in the middle. You could do it on the bottom, as long as it is on every page. We have a comment that you can put a report number on each page instead of the address. It just has to be unique. So if you want a report number, that's fine. As I was saying, the last name and the property address is just my personal preference. I don't want to have to go back and cross-reference a report number, but whatever works for you. There isn't a restriction there. It just has to be unique. Okay, key components of the form. The client inspector information. We just talked about how that should be used, but that is the first part. The next part, purpose, limitation, inspector, and client responsibilities. Well, this should look familiar. I remember our discussion about the consumer notice, and I told you that the consumer notice was a part of what's in the promulgated report down here in the preface. This section of that report offers the inspector a lot of protection, frankly. It tells what we're looking at. It says, here's some things that we have to look at. It says, you know, there might be things we can't see. So we'll kind of talk about that in more detail in a little while. Additional information provided by the inspector. After that sentence, after the line that says additional information, there are no limitations in what you can put between there and the next part where it starts with structural inspections itself. I'll show you some choices, but there really are no limitations there. And then the form itself starts. So let's just start at the beginning. Purpose, limitations. This is a part of the promulgated report, the preface that I showed you that was kind of highlighted. This property inspection report may include an inspection agreement. It doesn't have to. It is up to the inspector to choose to do it. It's simply saying that It may. You can have addenda to the inspection report, and what that would include is entirely up to you. We'll talk about that in some detail in a little while. I use that quite a bit. There's a lot of times that I want to provide some information, and I just include it back there. And other information related to property conditions. We'll talk about that in a little while, so I don't duplicate it. And then this is in bold as it is in the document. It is important that you carefully read all of this information. I think we all know that clients don't read all of the information. They are looking for that portion that you have highlighted in some way, or they're looking for that portion that you have emphasized, or they're looking for comments made around a photograph. Unfortunately, the assumption is that unless it stands out, it's just really not important. I can't tell you how often I emphasize to the client that they need to read it. There's more to it than just finding out this is wrong. There's also that, you know, if you take care of this, you might keep it from failing in the future. We talked about the fact that some clients expect that you are able to see in the future and tell them what's going to break. I give enough information that they know I can't tell you when it's going to break. It works right now, and you should do some things to make sure it's working in the future. An inspection addresses only those, I'm sorry. Excuse me. For those of you interested, the brownies are ready. Okay, an inspection addresses only those components and condition that are present, visible, and accessible. Well, how often do we spend our time defending against things that we can't see, or that weren't there, or we couldn't get to? It's right there in the preface. So when they say something to us, hey, I read your report, and refer them to the report itself where it says this. And remember, this is a part of the consumer notice. While there may be other parts, components, or systems present, only those items specifically noted as being inspected were inspected. Other parts, components, or system, that would be some of those optional things that aren't really covered in the standards of practice. There has been a lot of discussion about the fact that inspectors may have done a great report, but if they don't check the boxes, they're still not doing everything they should, and they will be held accountable. Check the boxes. Not required to turn on decommissioned equipment, systems, utility services, apply an open flame or pilot, or light a pilot in order to operate any appliances. Well, a question a while ago was about winterization. If I have a winterized system, I am not touching it. Too much liability. If I have a pilot that is off, I'm not required to light that. On the other hand, if you have a pilot that might be lighted with a spark igniter, that's not excluded necessarily because you're not using an open flame to do it. Utility services. Don't turn on water, don't turn on gas, don't turn on the electricity. We don't know why it was turned off in the first place. Quite often, we'll run across a client or a property that's been vacated, and the seller thinks that they're saving electricity or preventing some damage by cutting everything off. They cut it off, I'm not turning it back on because I'm not certain why, especially following the freeze that we had. No telling why some of those things were turned off. Not required to climb over obstacles, move furnishings, or stored items. This is in the report, not from us, the inspector from TREC, saying, I don't have to do that. I'm not required to do that. I have seen some inspectors not move a fishing pole, or actually there was a 5 fishing poles from in front of an electric panel in order to inspect it. They simply said it was not accessible. I didn't inspect it. You're going to have to defend yourself, I believe. You're not required to. You've got to be reasonable. I would definitely, definitely take a photograph of anything that limited your ability, or you claim limited your ability to access. A question about a dead thermostat battery. I carry thermostat batteries with me. I don't think that I'm going to risk anything by replacing the batteries. If you do, I'd be happy to hear it. But I have experienced that the client thinks I'm going above and beyond replacing batteries to be able to say the system's working or not. I carry a lot of batteries, a lot of different size batteries, and that has been very helpful to me and appreciated by the client. What about lighting a gas fireplace? It says I don't have to apply an open flame. I do to a fireplace. I'm doing that because it helps me understand the drafting of the fireplace. It helps me understand the volume or lack of volume, or how the log wand, if it's or the gas wand is operating. Many times those orifices are closed. So that is one where I know that I do not have to apply an open flame, but I choose to apply an open flame. I also, if I have a range or a cooktop, a gas cooktop, where it's not automatically igniting, I will use an open flame to verify that I've got gas, as opposed to the igniter's working and the gas is not. So I'll know that the gas is working and the igniter's not. The inspection report may address issues that are code-based or may refer to a particular code. However, this is not a code-compliant inspection and does not verify compliance with manufacturer's installation instructions. You know, so often they think it is, the client thinks it's pass-fail. So I emphasize again in that section, that's information provided by me, that it's not a code inspection. It's not a pass-fail inspection. I am following the standards of practice. Now, we all know that to be a good inspection or a good inspector, you should have a lot of knowledge about code, but don't pretend it's code inspection. How often do codes change? Are you trying to base a current code against a construction that's 40 years old? You can't do it. Now, there may have been a code back then that's the same as the code now, but worded differently and in a different book, whether it was BOCA versus ICC. But if you start looking, if you start treating it in terms of a code-based inspection, then they can come back and try to hold you accountable. They might not be successful, but I think we have plenty of people that can tell you that the defense of an inspection report is expensive, whether you are right or wrong. So I emphasize it's not a code compliant inspection. If you want to document the reason that you're reporting something is deficient, use the SOP. I actually put the SOP reference number in there. Does not imply insurability or warrantability of the structure. Well, that usually is applied to roofing. Many of the underwriters along the Gulf Coast area will not insure a roof that's more than 15 years old, or they will apply a premium to insuring that. So if I imply that the roof can be insured and they are out of the option period, then they come to me and say, well, you said I could get insurance for it, or you didn't say I couldn't. You didn't tell me it couldn't be warranted. And in warranty, I see more people worried about the foundation. We don't know. All we're saying is, here is what we observe, not pass fail, not code, just observation of deficiencies as defined by the SOP. Some safety issues may be addressed, but it is not a safety or code inspection and not required to identify all potential hazards. You know, we can walk through the house and there might not be something that stands out as a code that says it's a safety issue. But we talked this morning about tripping on carpet. That's a safety issue. Unsafe decks, that's a safety issue. Code inspecting that deck, but I can wiggle a handrail and know it's unsafe. I'm not required to identify everything, but I really ought to be able to, and should, and I think I'd be held accountable for those that are readily apparent. If TREC is stating that the report may contain code-based comments and yet the inspector should be IC certified to perform phase inspection, is it a contradiction? I wouldn't see that as a contradiction according to TREC, because they're simply saying phase inspections have nothing to do with them. They're not trying to get you to follow any standards of practice with regard to phase inspections. And understanding construction enough to do a phase inspection is far and above beyond the standard that you would have to have for a TREC inspection. So I don't see that as a conflict, personally. General deficiencies include inoperability, material distress, water penetration, damage, deterioration, missing components, and unsuitable installation. You know, it's pretty straightforward if something doesn't work using normal controls. Turned on the AC, it didn't cool. I turned on the AC, the fan didn't work. Outside at the condenser, inside at the air handler. The range did not light. Well, that's pretty easy. Material distress, to me, is a little more complicated. At what point is that distress something where it becomes deficient? So we see blemishes, and we see damaged finish of building materials. If we see wood destroying insect damage, if we see rot, if we see rust, if we see rust jacking where the rust is expanded to the point it's causing distress to the masonry veneer or stucco, at what point is that a deficiency? One of the things that I have done for years, if I don't think it is currently failing, I'll say something like, I see early evidence of. I don't have to say it's deficient, but I see early evidence of what will become a deficiency. That's always going to be a judgment call. What about the roof covering? We see hail impact. We see branches that have rubbed it. We've seen wind that has ripped it. We have seen the granules that have come off just because of age. You're going to see, I believe, more material distress in the roof than many other things. Water penetration. You have two kinds. You have active water penetration, and you have evidence of previous water penetration. You are required to report evidence of water penetration, whether it's active or not. So that's a stain. We talked about earlier that we don't have to positively determine where that water came from, but we need to be able to say that we see water penetration. Now that is, in my mind, separate from the material distress, because we can see stains that really haven't distressed the material to the point it's failing. We can see latent water damage that causes the gypsum to fail, but not every stain means that you're going to have a failure of the material. EPA says that if you have less than 10 square feet of water staining like that, then all you need to do is use a material like Kills and then paint it. I'm okay with that. I see water, I report that I've seen water, but not necessarily that it's damaged at this point. Damaged. Well, that would certainly be the more extensive material distress in building components, whether you have failed rafters, failed purlins, failed struts, rafters that have cracked, or you see masonry veneer that is falling off, whether you see lintels that have corroded so bad that the brick is failing. Deterioration is going to be almost in the eye of the beholder. I would be cautious that if I look at it and think that it's distressed or damaged or deteriorating, I'm going to report it. Now, I might try to quantify it. I see early evidence. I see I see isolated. I'm going to do my absolute best not to say minor. I don't think saying minor anywhere in a report helps the client or protects me. Does the client need to sign this form, and if so, where? A question. No, this is in the preface of the promulgated report. It is a part of the consumer notice. There's nothing to sign. It is just a part of what you deliver to the client. Missing components. That can be, I have almost overlooked things, and I have to go back and remember that the standard of practice talks about missing components, such as a knob for a range. You don't really think about that much. That knob is broken, that knob is missing. It really doesn't matter because I can take that knob and put it over here. But as minor as it seems, you're required to report it. So missing components might be small, but you need to do it. So you don't need to check the deficient box, for example, if you see water stains. I thought you did, and if we do, are we wrong? This is just an example. I'm confused when we check deficient. It says report evidence of water penetration. That is information to the client. The evidence of water penetration in and of itself is not a deficiency. The definition of deficiency is adverse and material. So the fact that there is a water stain isn't necessarily an adverse and material issue, but there is nothing to stop you from putting a deficient check. And you can always say, I am doing this to draw your attention to the fact that there was water penetration. There are very few items in my reports that aren't deficient. Am I being overly critical? I don't think so. I think I'm telling my client everything that the client needs to know about it. I see a water stain. I say, I see a water stain. I say that there is no indication that water is active at this time. If I can tell them, hey, I think it came from the water heater. And by the way, the water heater's been replaced recently. I think it came from the AC system. And by the way, the AC system's been replaced recently. I think it came from the roof. And by the way, the roof system has been replaced recently. Same thing with water supply lines. If I can't, then I say, I see water penetration. There is or isn't active water there at this time, and I can or can't see where it's coming from. In and of itself, water penetration evidence is not deficient, but I have quite often checked the deficient box just so that they don't overlook it because the box isn't checked. Will you get in trouble for checking it? I don't see anything that says you'll get in trouble for checking it. What I see is you get in trouble for not checking it. Missing components. Okay, we talked about that. Unsuitable installation. There's two things that really stand out here. One is that unsuitable installation might be code-based. It might be your evaluation of the installation based on code. It is also likely that it is based on the manufacturer's installation requirements. It's not a code inspection, and you're not expected to go track down every manufacturer's installation documents, technical documents, etc., for every component in a house. But the better you are at inspecting, better you are at teaching yourself, the better you are at follow-up when you come across something you don't understand, then the better you're going to understand suitable installation versus unsuitable installation. Okay, I'm seeing a couple of questions in the chat box. I'm not going to look there if you don't mind. If you have a question, put it in the Q&A section. Unsuitable installation. Well, you have a air handler, a furnace and air handler. So it's gas heat, and it is designed for horizontal and it's installed vertically, or it's designed for vertically and it's installed horizontally, or it can be either. How do you know? It's going to be very difficult for you unless you look it up. So if I see what's clearly a vertical installation based on labeling, the nameplate, etc., or horizontal, that's clearly horizontal, that's one thing. I'm not going to go looking up the manufacturer's information unless I see something that looks odd. Well, what about ranges? We know they need an anti-tip. I don't need to go look things up like that. We have wet traps and sediment traps in gas pipes. You know, the designs are different. Wet trap is supposed to be installed in multiple locations, anywhere in the low portions of a gas line that is wet, and a sediment trap is at the water heater and the furnace. The definition of a deficiency in the SOP is much different than what TREC is stating as a general deficiency in this quote. It can be confusing. Yes, the general deficiencies it's reporting here is one thing, and these are where they might be specific in the SOP. But if you're trying to decide what's deficient or not, the definition of deficient is adverse in material. Because there's many things that are not necessarily material, that are, what if we have no wet traps? That's probably a poor explanation, because there may be some part of the state that has wet gas and would need that. What's a good example? Anybody can think of one? If it doesn't work, that's material. If it's distressed or deteriorated, that's material. Unless it's what I described a while ago, like maybe the paint itself is starting to flake out. Water penetration, I have to report it as information, but not necessarily as a deficiency. Missing components, pretty straightforward. It says I'm supposed to report missing components. Hot and cold water orientation is one that's been thrown out there. To me, that's safety. And I will report it, and we're supposed to report it because it's specific in the SOP. If you would turn on the water expecting it to be cold and it's hot, you could get injured. Attic access stairs fastened with drywall screws. Okay. To me, that's safety, and I absolutely report that. I also report it if they don't have fasteners in the corners. That is not anything that's going to be specific to the standard of practice, and it's going to be specific not to code, but to the manufacturer's installation instructions, but they're not on every stairway. But that's okay. I can say and justify the weight, all of the tension on this stairway is at the corner brackets. Put fasteners in the corner brackets. I can say that typically manufacturers call for this kind of fastener. Put it in there. And I consider it deficient because it's not there, because I don't consider it as safe. Good examples. Not required to prioritize or emphasize the importance of one deficiency over another. How many times has a client said to you, what is the most important thing? Give me the top 5. I don't answer that question. I will tell them the most expensive repairs are likely to be. I will tell them that the safety issues are, but if I start prioritizing that, and I'm not taking into account that their half-step neighbor-in-law might be an electrician that owes them money and will be happy to do that for free. So in my mind, I simply say, you have to figure out what's going to cost you most or put you at the risk. Now, I don't mind talking to them about it, but I'm not going to document that, and that's for sure. But I don't have to prioritize. A lot of agents want to know the top 5 items. Very difficult for me to answer because with the exception of AC and plumbing, most everything I need done, I do myself. Improper use of extension cords. I consider that to be a material safety item. And it all depends how that extension cord is run. I think we've all seen extension cords in the garage, kind of stapled to the ceiling. All right, technically that's wrong. A flexible cord cannot be used, shall not be used as permanent wiring. But that's pretty straightforward. I can look up there and see whether or not there's any damage, or even see whether it's subject to damage. What if they have it laying across the brackets or the tracks for a garage door? That's going to be more unsafe than some of the properly stapled runs of cord across the ceiling. On the other hand, I have seen a house where they used extension cord inside the wall as the primary run to a light located outdoors. So it went from the switch box through the wall, out the soffit, down the eave to a security light. That's pretty, that's very material in my mind. It was okay though, because the owner of the property worked at Home Depot, and so he considered himself an expert at that. I think the only expertise he had was plenty of availability to extension cords. Don't have to prioritize. The emphasis is in the report, or it's on the form. I didn't add that. It is not technically exhaustive. I'm not going to find everything. I don't give the client the impression that I'm going to find everything. Even if I pull out a thermal camera, the first discussion I have is it does not see through walls. It gives you a color picture of temperature differentials that doesn't guarantee that there aren't some things concealed because everything's at the same temperature. I've proven that with a client by pointing to a wet spot that I proved was wet, but it was exactly the same temperature as everything around it, and it didn't show up on the thermal camera. I'm going to find those things that I can detect through operation of equipment and normal controls, or I can see damage, or I can see evidence that something is damaged. That's a part of it's not a code inspection. You can't do it all. Everything I'm doing is based on the standards of practice, and this part of the document, purposes, limitation, and client inspector client responsibilities, is as good a summary of what your inspection is and should be than almost anything else that's out there. So make sure the client reads that. That's the value of including that CN notice in the form. Helps to reduce some of the risk, but can't eliminate the risk. I can't tell you what components are going to fail. And when they ask me how long it'll last, I tell them the minute I walk out the door, it's going to break. That's what you should expect. It's going to break when I walk out the door. And I don't care if it's 1 year old or 50 years old. I can't anticipate future events or change in performances due to change in use or occupancy. Let's talk about the future events. That means that I can't tell you when it's going to fail. I can't tell you at some point it won't leak, that the water pipe won't leak. But now the changes in performance due to changes in use or occupancy. So you have someone moves in and they use more hot water than they used to use. Well, you may have had a single person that didn't take very hot showers and didn't take long hot showers, and the water heater worked fine. But now you have somebody move in and it's 5 people, including 3 boys that do sports every day, and that water heater is not going to handle the demand. Same thing with the HVAC system. Somebody might like it at 78 degrees. Somebody else moves in and wants to keep it down at 72 degrees, and it just can't keep up. We're operating that in normal modes. That doesn't tell us how well it's going to handle something in an environment that we can't anticipate. Jim Heim made a comment about the use of extension cords is specific in the standards of practice. Thank you. Exhaustive. The definition of that includes all possibilities, thorough, conducted an exhaustive search. Okay, well, that's pretty straightforward, but look at all the possible synonyms for that. All out, clean, complete, comprehensive, full scale, out and out, thorough, total, all inclusive, in-depth, global, unrestrained. We can't do that. And we certainly can't do that in the time period that's allocated. Now, if somebody wants you to do that kind of inspection, it is far beyond the TREC inspection, and I would price it accordingly. I've had people ask me to do an exhaustive inspection, and I showed them the standard of practice. I showed them the consumer notice. I said, here's what we're looking at. and it's going to take me about this long. And if they want me to do more than that, it's going to take me X amount of time, and I'll be happy to do it. It'll cost Y number of dollars. Most of the time they fall back and understand that the inspection we're doing, while not exhaustive, is pretty good. And if they talk about exhaustive, I say, then you want me to remove covers from every receptacle and every outlet. You want me to remove fixtures and look at the quality of the wire connections and splicing. Once you explain what your inspection is, I think most clients aren't going to have a problem with that. At the same time, they'll understand that there are things that are going to be missed. And the fact that that can happen is going to be documented in the preamble to the report. It's going to be documented in the consumer notice. It's documented in my inspection agreement, and it's documented in the standards of practice. You should also attempt to determine whether repairs, renovation, remodeling, additions, or other such activities have taken place. One of the things that I always point out is when there is evidence of repainting, retexturing, refinishing, remodeling, add-ons, etc. And I tell them that this is expected. I expect that all of that work concealed something. And I have no way of knowing what's concealed. And I have no way of doing any investigation of what might be concealed that doesn't involve damaging to the finish of the property. Given that, they're just going to have to understand that I can go, yeah, it looks like they've cleaned this place up. I don't know what they've hidden. But by the way, because of this, you should not be surprised if someplace down the road you get cracks and you get some things that are that would make you think the foundation has a problem, or this has a problem, or that. One of the most obvious is when they recondition tubs, or when they refinish tubs. I can just almost guarantee you that means that around the tub shoe fitting and the drain and the overflow, especially on these old cast iron tubs, that there's or steel tubs, that there's corrosion. Point out what you can, and it will help you remember that there might be some things there that are hidden behind that, maybe let you do a little extra work. Not that much extra, but focus to see if you can't determine the why of it. Not your responsibility. We're telling this to the clients in the form. It says it's not the inspector's responsibility to confirm that the seller's disclosure is complete or accurate, or that this inspection is complete or consistent with opinions expressed in previous or future reports. So you are to do an inspection based on here and now. That doesn't mean you have to go back and look at the seller's disclosure. You don't have to look at previous reports, and you aren't responsible for future reports. You're responsible to the standards of practice as visible, accessible, operable on the day that you were there. When a deficiency is reported, it is the client's responsibility to obtain further evaluations and/or cost estimates from qualified service professionals. Mr. Inspector, how much is that going to cost to fix? Who do we get to look at that? What do we do? What do you do? When I find a problem, if I believe it can be or should be further evaluated, I tell them that. that about recommending further evaluation is not a substitute for a complete inspection of that. We talked about foundations. I see a crack, you need to call an engineer. Okay, but what's your opinion about the foundation? The oven was outside the 25-degree tolerance. Okay, what's your recommendation? I talk with the client, let them know, and this is why I like them there. I tell them that you have this 25-degree tolerance, but you know what? My thermometer is not a calibrated tool, and there should be some expectation that there's variances there, and the oven might be working fine. Here's what I'm seeing. I set it at 350. I got 370 degrees. All that I have under normal conditions says that works fine. Can't tell you what else you should do about that. I can tell them easily enough that the roof has got a lot of wear and they ought to follow up on that, that the foundation has a lot of cracks and they ought to follow up on that, that the AC is more than 5 years old, and it's probably worth having more evaluation on that. Or the foundation's not, I'm sorry, I said foundation, I meant AC. The AC is very old and you should expect limited life. I'm not going to tell you what the costs are because I don't know. Yes, there's software out there that will allow you to plug in some information and they will give you estimates. And the estimates are so broad that as far as I'm concerned, they're worthless to my client. So if they want to know how much a roof costs to replace, I tell them anywhere from $20,000 to $40,000. And I just make it so broad that they understand that it's a worthless estimate. And any such follow-up should take place prior to the expiration time limitations, the option period. When I make a recommendation for them to follow up, I do say it needs to be done within the option period. I don't want them coming back to me and saying, well, you should have told me. You should have told me. But if they do, I say, did you read the report? Yes. Did you read this part of the report right here? Oh, no, I didn't think it was important. Well, now you know it is. This is a part of the consumer notice. If you read this carefully and be prepared to defend your report with this, or encourage the client to read this, I think everybody is going to have a much better understanding of the report. Evaluations by qualified tradesmen may lead to the discovery of additional deficiencies, which may involve additional repair costs. One of the inspectors that was on IAC and taught for years made a comment once that stuck with me. If you hire a professional to follow up, to further evaluate, and they don't find any more than I did and reported in this inspection report, then you need to get another one. You need to find somebody else, because you shouldn't expect that I have found it all in my non-exhaustive inspection report. So let them know that there might be some things that will show up, that will occur, that might be concealed, that cost you more. And make sure they know that that's why they need a qualified tradesman, not somebody that's just going to come in and look at what I reported. Failure to address deficiencies, and that's you, Mr. Client, Mrs. Client. If you don't address those deficiencies, if you don't address the comments, if you don't address the recommendations that I made, you may have more problems, whether it happens the day after tomorrow or in 2 years or 3 years, and you're going to have repair costs that are only going to get bigger, larger. You're going to have more costs. And not required to provide follow-up services. You can certainly choose to do that. And you can choose to do that for a price, but there's no obligation to you. It's 2 o'clock. That's going to be time for a break. But I'm going to answer this question. When an AC system is using R22, do you mention that to the client? I absolutely do, because that means that it is less likely that that system can be easily and inexpensively repaired. It is more likely, certainly because of age alone, it is more likely that that system will have to be replaced. And if you want it, I have verbiage that I'd be happy to give you that tells you exactly what I say to my client when there's R22. A Q&A. So earlier I asked if we can add a table of content page after the TREC intro before the actual report starts. If you put that into that section, more information provided by the inspector, yes, that is not a problem at all. Another one, I already add my info page there. So after or before that, I've asked TREC without any luck. I added my info page there. Oh, this is back to the table of contents. Okay. Well, I would tell you again that after it says additional information provided by the inspector, you have no limitations until you get to that system, Roman numeral 1, structural systems. You can put your table of contents there. Do you put it very first or after what information? I'd be happy to talk to you about that outside of this class. I'd have to see a sample of your report, so maybe send me that and I'd be happy to talk to you about it. Is that, oh, R22 verbiage. Thank you. I went during that 10 minutes and I looked it up, and this is what I told you about having to follow up on your own library of comments. What was interesting is that library comment is obsolete now. It's out of date because of the changes. The end of that time period was 2020, and I wrote that as if it was prior to 2020 and saying, here's what's going to happen. So now I need to rewrite it and saying, now we're past 2020 and these are the restrictions on R22. But to get back to the original comment, I absolutely do note for the client as information, as important information, that they have R22, which can affect cost of repairs or replacement to that equipment. Good question. I think we ended, or we're talking about not required to provide follow-up services. The biggest issue there is that they want to know when you're coming back to make sure it was done, because they think that should be, the client thinks that should be a part of the services. And obviously it's not, unless you want to do it and want to charge them. And I've done it both ways. I've charged them to go back, and I have done it for free. Depends entirely on the client, the circumstances, and the distance to travel. Some items reported may be considered life safety upgrades to the property. It's not a code inspection. We're not going back and saying that it wasn't required then, it is required now. One of the common generalities is you can't grandfather safety, but we do report things all the time. We say that you do not have the smoke alarms that are required in the locations today. So smoke alarms are required to be on every floor, in every sleeping room, and immediately outside the sleeping room. And that's what we're required to report. If they aren't there, it's considered deficient without regard to when the house was built. GFCIs. Now, GFCIs are one of the things that are expected to change a little bit in the draft SOP. Likewise, arc fault devices are likely to be addressed in the revised proposed SOP. So we may say that, how about safety glass? Another perfect example. Older homes didn't have safety glass where it's required to be today. So you're not reporting that as code, you're reporting that as it's unsafe. Today it's required to be safety glass and it's unsafe without it. Question Q&A, how do we determine if an AC uses R22? It is on the manufacturer's label. It tells you the type of refrigerant in the same way it tells you what the circuit minimum size and the breaker maximum size is. That's one of the things I told you that I do take pictures of it. An agent told my client that it was my responsibility to make sure appropriate repairs were made. The follow-up discussion was a learning experience for the agent. I imagine it was. Ray, I imagine that was a fun conversation. I'd like to know who did the leading of that conversation. And for more information, refer to Texas Real Estate Consumer Notice concerning recognized hazards or deficiencies. Starting right there. This is the consumer notice. Each year, Texans sustain property damage and are injured by accidents in the home. While some may not be avoidable, many others may be avoided through the identification and repair of certain hazardous conditions. To ensure that consumers are informed of hazards such as these, TREC has adopted standards of practice requiring licensed inspectors to report these conditions as deficient when performing an inspection if they can reasonably be determined. Well, that goes to safety glass, extension cords, missing GFCIs, AFCIs, CSST. Examples provided include this. Well, what we just talked about, I'd have only said it once if I'd realized it was the next page, but the things that you see here, these are changes to code. And in fact, some of these things had to be developed recognizing that they're safety issues. So the last I heard is there are about 5,000 lives a year saved by the use of AFCIs. I don't have a number for GFCIs, but certainly people have been shocked, some worse than others. So we check for improperly installed or missing GFCIs, malfunctioning AFCIs until adoption of the proposed new standard of practice, the installation of safety glass where that isn't, which would be above tubs, next to doors, in stairways. And I'm not going to get into actually all of the requirements for that, but basically those are things next to doors, above tubs, in stairways, sliding glass doors, glass inside swinging doors, all of those places. My sons, when they were in the 5 to 6 year old range, were upside down, or they were in what was called a dog-loo, which was a dog house that looked like an igloo. And they were having a lot of fun rolling around on it when it was upside down, and they rolled into a sliding glass door. and it wasn't safety, and it shattered. And when I ran out there, there were shards of glass, and I'm talking about large shards of glass. And it was just God's grace that those kids weren't cut, killed. And so I'm just especially cognizant over the lack of safety glass. Lack of smoke alarms, fire rated doors in certain locations, functional emergency escape and rescue openings in bedrooms, and malfunctioning carbon monoxide alarms. So we're not right now required to report missing carbon monoxide alarms to today's standards, but those that don't work. Whereas with regard to smoke alarms, we're required to report them if they're not where they should be today. I think my carbon monoxide alarm is possibly going to change in the proposed SOP. It doesn't address all of the required locations, but it does will possibly require us to report them missing from certain areas. Fire rated doors, that's typically going to be between the garage and the house. Functional emergency escape and rescue openings in bedrooms. How many of you have had windows that you've looked at that had security bars? How many have seen windows that have been screwed shut? How many of you have seen older homes where there is no openable window, or the window is too small? The 5.7 square foot opening for a window, the calculation there, or the design, is so that a fireman with a backpack, the oxygen tank, can get through that opening. Many times I have found homes that had a window that didn't open, or a window that was too small. And I include the fact that you have windows that are too high in bedrooms. Today, the limit is 44 inches above the floor. It used to be 48. So the fact that it's higher than 44, I report as a life safety issue. Excessive spacing between balusters on stairways and porches. That's the greater than 4 3/8 inch on the open side of a stairway, or greater than 4 inches on the landings, balconies, and decks. Those are changes of code. I also have a comment that I make under stairs, and says basically that the design of stairs have changed over the years. And I'm not trying to pretend that this stair was built to code or wasn't built to code when it was constructed, because I don't know what that is. But these findings that I'm about to report are based on the current safe design of stairways. That, or I tell them they should just make sure they have kids with big heads. Properly installed appliances. That would be everything from the lack of an anti-tip device on a range, to a dishwasher that's not secured to the cabinet, to the lack of backflow prevention on that dishwasher, to water heaters that are installed unsafely or in an unsafe location, improperly installed or defective safety devices. I guess that would be above and beyond those things like smoke alarms, smoke detectors, I should say. Smoke alarms is better than detector. Fire detector, if they have such a thing. Carbon monoxide alarm. So any of those things. The biggest deficiency I see with those is where they're located. They may be located in corners where they're not effective. They may not be close enough to the roof, the ceiling, and a vaulted ceiling. They may be too close to ceiling fans and bathroom doors and supply and return air registers. All of those are specific to location of those devices. And that's not just the manufacturer devices, that's in code. Lack of electrical bonding and grounding, and lack of bonding on gas piping, including CSST. That was the thing that was added sometime back. It was the change to this document, just recognizing that the lack of bonding on CSST makes it less safe than it could be. A lot of discussion. We've had a lot of classes on bonding and grounding and bonding jumpers and the proper way. And what it really comes down to is we can't always tell that it's properly bonded and grounded. What we are more often able to say is that it is not, or there is not evidence of bonding, or there is not evidence of grounding, or that there's a failure of the grounding system, whether it's a loose clamp, broken ground, corroded ground rod, any of those things. All right, now we get into the additional information. Before we talk specifically about the table of contents question, let's just talk about some things that I see put into a report in this other information. And this is most of this is based on my own documentation. I put the size of the house in there. I put the age of the house and the type of the house. All that, I think personally, is pretty critical to describing the house and the inspection that you're about to perform. It tells you that there is a large house, the size of the house. An older house is likely to have more problems. Description of the house tells you perhaps that there's some things you can't look at in a townhome and condo. Number of stories, bedrooms, baths, garage bays, garage doors. Just a simple description of the house. Occupancy. What does that do for us? Well, it establishes very early in the report when somebody's reading it that there are going to be some things that are concealed. In an occupied house or a staged furnished house, that furniture is going to keep me from getting to things. Now, most often it is going to be receptacles. It is also going to be windows. Less often it's going to be doors, but it is obviously going to be walls. How often? Well, we had a discussion a while ago that you remove cabinets, you remove shelves, you remove furniture. You can see damage, including moisture, that simply could not be seen during your inspection. Start time, end time establishes how long you were on the job. You know what? I think that protects you somewhat. I had a 1,200 square foot home and I was there for 2.5 hours. I had a 6,000 square foot home and I was there for 10 hours. Weather condition. It was raining, thundering, lightning, and I wasn't going on the roof, and the electric panel was located outside and I didn't open it. Persons present. Well, you know, I did that inspection and so was there and could prove it. The seller let me in. The seller was there to answer some questions. The buyer was there. Termite inspector was there. The client and family were there. Tradesmen were there to look at the carpet, to look at the cabinets, to discuss painting. Direction the house faces. That just is good to help you establish a reference point. House faces north. So I saw this on the west side. I saw this on the east side. I saw this here or there. Lacking that, what I generally say is on the left side, and the reference is the street. So standing at the street, facing the house, left side, just so there's no confusion on where I'm trying to describe in my report. Notices and disclaimers. I'm going to kind of link and lump that with inspection agreement. Notices, I told you in mine, I emphasize that this is not a code inspection. It's not a pass-fail inspection. And in fact, let's just kind of look here. I've talked about what they are, but this is the first part of mine's additional information. You can see that I just kind of showed you some of the things that I described. If it is actually raining, which is down there about the 6th or 7th line, I say it was light to moderate. It was moderate to heavy. It was rained over the entirety of the inspection. It rained at the beginning. I just give some information to describe the conditions I was in during the inspection. This is the verbiage I put. This is the disclaimer that I put immediately after that. Now, in my document, I have that first sentence in bold. This was neither pass-fail or a code inspection, though looking at that, I think I need to change or to nor. This was neither, no, it's neither or, either or, neither nor, neither nor. I have to change or to nor. I'm just going to let you read that so I can take a drink. Some of this is exactly the same as in the preamble. But I already told you that I know that a lot of people don't read that. So I say it again. And one of the things I've adopted started about 5 years ago when somebody said that I didn't tell them, and I pointed out where it was in the report, is if I have something now that I want to emphasize, I put it in a box like this. I put it in a color border and a colored background, and I make it stand out. I don't want anybody to think I was trying to hide it. If I'm trying to do a good inspection, I want them to read this. I'm just going to put it there and tell them and force them to see it. And so if anybody is reading this report, and let's be blunt, in a court of law, I don't want there to be any question but that I showed it to them and emphasized it. So this is a note that I put. Now, I don't know that you can copy this with a screen capture or not. If you want it, email me. I'll send it to you. I'm not proud of it. No, I am proud of it. I'm just not. I'm willing to share it. Okay. My email is clay@gracehis.com. My phone number is 713-503-1820. So text me if you need to. Can I cut and paste it to the chat? No, apparently not. But I can get it to you. Take a picture with your camera on your phone. I'll let it sit there for a second. Or it's going to be in the recording that you can look at. So you'd be able to scroll to this section and look at it. But I'll get it to you if you need it. And something else, guys, this is just what I do. Some of you may have something that's better than this. If you've got something you want to share, Facebook has become a great place to share some good practices. And Justin, where is the note in my report? It is immediately past this. So just under this section where it says buyer or present at the inspection, I put that. One of the other comments that I put in this section, and again, some of you may have something better. I'm telling them, I don't know if it's ever flooded. I don't know if it's ever had windstorm damage. I don't know if it's ever had other damage, like instead of flooding, whether water heater leaked and caused all sorts of damage. All I can do is look at what's there right now and recognize that stuff may be hidden. There's something called a comprehensive loss underwriting exchange report, or CLUE. This is something that underwriters use current. And if you look at a property address, it will list every loss or payout for loss on a property. So that means that if there was flooding damage and an insurance company paid off on it, it would be on that report. It is a way that somebody can look into it to see if there was damage that was not disclosed. And this transcends property owners. So it may be that an owner had damage and sold it to somebody who wasn't aware of the damage, who sold it to you without disclosing damage because they weren't aware of it. I am not responsible for getting this information. I don't take responsibility or want responsibility for it. But I have no problem with telling the client that I can't tell you if it's had damage. But you know what? Here's a way for you to find out. Your insurance company has access to that. Ask them for it. How many times are you on the job site and you're just talking to the client and you go on and on and on and on, and then you get back to your office and you're writing the report, and all of a sudden you realize that maybe what you told them wasn't quite right. What's in the documentation is what stands. So if you say something wrong, or if I say something wrong, this notice is in the report regardless. But if I say something wrong, then when I deliver the report to the client in the email, I will tell them, hey, this is what I said. I've done a little further evaluation, investigation, research, and I found out that this is the fact. I don't mind telling them I learned something, but you really need to make some sort of documentation that it's the written, well, let's see, supersede any written or verbal. So it really should be, this report shall supersede any verbal conversations, comments. Okay, here it is, I'm sorry. Any written or verbal conversation, comments, or report prior to providing this written report. So that's saying this written report supersedes anything, which might include a note I made on the job site. Additional pages may be attached. Read them carefully. It's not complete, in my opinion, without those attachments. So if I attach some manufacturer document because I want them to understand that that's the basis of a comment, you've got to read that. Don't throw pages away and believe that the report's complete. And that I may provide comments whether I think it's deficient or not. In the same way that I talk to a client on the site, I might say, hey, here's here's just some information for you. There's really nothing I see that needs to be fixed, but here's some information. That doesn't mean it's deficient. It's only valid if it gets reported. There's another intercarrier database that's more accurate. Clue is run by Experian. What is the other intercarrier database? I'm not aware of that. ISO. 90% of the carriers use. Okay, great, Brian. Thanks a lot. One more thing I have to learn. No, seriously, appreciate it. ISO, Insurance Services Organization. So looking at that, I'll tell you that I'm perfectly willing to update that previous comment because I think that that's just one more. Use Clue or use this. Brenda, you deleted that pretty quick. Brian, can you put that in again? The reason I used Clue and was aware of Clue is because when the attorney asked me that on the witness stand, I had to say I don't know. So I learned it very quickly. And Brian, that's exactly what I do. I just tell them to ask their agent. I make a comment about the Clue and now I'll use ISO, but I don't do anything other than advise them that it's a good answer, good thing to go back to their insurance company with. All right, systems and components. Now we're talking about the form itself. How to fill out the report form, what is required. Noting observed deficiencies and other items required to be reported. Because there are some things that are not deficient necessarily, but are required to be reported. Shall indicate by checking the appropriate boxes, whether it was inspected, not present or deficient, and explain the findings. So you can't simply mark it that it's deficient. You have to say that here is what's deficient. You also are able to say that it is both inspected and not inspected, whether it's deficient or not, because there are some things that you simply might not be able to inspect. Perfect example, in my opinion, is a gas water heater. When the gas isn't owned, I can still inspect the physical properties of the water heater. I can even test the relief valve. It's not as effective, in my opinion, because the water's not hot, which may affect how it resets or reseats, but I can't claim to have inspected the performance of it. So I will do that quite often, inspected, not inspected. What can be added to the form? Your own custom cover page. Now, this would be the very first page in the document. You can use it for a lot of different things. You want it to snap. You would like it to have the client's attention. You want it to be the first thing. So if they pass that report around, somebody looks at it and can see, oh, here's what was inspected. And in my case, I used some information down there to show my certifications. You can add headers to each page. And in this particular case, the bottom example, the only difference in the header is that I used or I put a logo, and no, that's not my logo. That is pretty cool though. So that's just an example. You can add footers to each page. Sorry. You can add footers to each page except the first page. All right. I've seen information from TREC that says either of these two things. So one of them is that the footer of the first page cannot be changed. That would mean that it is promulgated as page 1 of X number of pages, unless you put a cover page, in which case this would be page 2, except that you can't change the 1 to a 2. And then the page 1 is the cover page, but it doesn't have a page number on it. This came from TREC legal staff. It says that you can add a cover page, but that means you have to renumber the pages, which would include the cover page. So cover page becomes page 1. But I've seen another email that said that you can't do that, which would mean that the cover page is page 0 and the first page is page 1. Frankly, I doubt anybody's going to get in trouble for doing it either way. I mean, if they can't even come to the same conclusion, then I don't think it's really critical. When I do it, I make the cover page page 1, which means that the promulgated page 1 is page 2. And I made that decision for one reason. When I talk to a client on the telephone and I tell them to go to page 18, I don't mean to tell them that's page 18, but at the bottom it says page 19. Or actually, it would say page 18, but at the bottom it would say page 17. So I use it as page 1 is the cover sheet. You can put anything after you want in the footer after the first page of the promulgated form, but you still have to leave that first line, real estate inspection form 7-5/05/04/2015, page 6 of, but you can put anything you want below that in the footer. The copyright, the interesting thing about that is there is legally, whether you put that in there or not, it's a copyrighted form because you prepared it. But if you put the copyright date in there, it just kind of gives a little more credibility to your claim that it's copyrighted. That the second sentence there, report prepared exclusively for the client. What is how paid? That's not the way I put it in my report. I think I did that as silliness one time. And it's not transferable to anyone in any form. I put that in there. It's in there in a lot of different places, but by putting it in the footer, I can just emphasize it. What can be added to the form? Footers to each page except the first page. Subheadings, we'll get to some examples of that right now. So under branch circuits, I might want to have subcategories, service disconnects, outlet switches, etc. Smoke and carbon monoxide alarms is an example. I don't have to put little lowercase I, double I, triple I. I could use numbers. I could use anything other than perhaps the capital B or capital letters there, because I think that would be confusing. You could also just have it justified a little different. You don't have to have that at all. In my report, which is done in Word on a template that I made, You can set headings and use the headings to create a table of contents for navigation, so that person who talked about table of contents and where you put it in Word, the headers would automatically create that table of contents down to whatever level of indentation that you choose. But you can break it down like this. You can also, as an example, add a section at the end. You can't put it between sections, but you can add it. So here the example was, you have a section under branch, which is smoke and carbon monoxide alarms, because that is a part of the specifications in the standards of practice under branch wiring. But what I can do is create this second, or this new subheading. That's what I chose to do. I have smoke and carbon monoxide alarms in a separate category, labeled C following B, obviously. Okay, so I'll take back to here. You can include captions, letters, and checkboxes. So just an example under fireplace. These are checkboxes I've seen in other reports. I don't quite use them this way. Would suggest it's a manufactured fireplace versus site-built masonry. Wood burning, gas-fueled, gas log set. I would suggest that if you're going to use checkboxes, you do a little bit more verbiage to make it absolutely clear what it is you're saying. So for example, it would be type of fireplace, manufactured versus site-built masonry. Type of fuel, wood, gas, accessories, gas log set, a remote control, a wall switch. And my examples down there at the bottom are, is there a proper hearth extension? Yes or no. Proper fire blocking? Yes or no. And the reason is that I have seen check boxes that I do not believe would be clear to a client reading it. To you, it makes perfect sense, but to them, I don't know that it does. Wood burning, are you describing what it does, or are you describing that's what's going to happen if you do something wrong? It's going to burn the wood. So you can add the check boxes, you can add captions, you can add an awful lot of things, you can add photographs. I'm simply saying that if you choose to use the check boxes, you make sure it's the client who can understand it, not just you, the inspector. A question: when we return, what are the limits in adding check boxes to subsections? There are none that I'm aware of. In fact, I would say there are no limits. After the word comments and the colon, after the word comments and the colon, you are free to put anything all the way down to the next section, K. So you can put just whatever information you want there, including check boxes and photographs and disclaimers and comments, etc. What cannot be added to the form? It's really less about what cannot be added than it is about what cannot be changed or removed, and what can be removed. Question: can you place pictures at the top before the words comment? No. So we come back to here. This between where it says fireplaces and chimneys and comments, you cannot put anything. There are some places that it asks for information, for example, type of pool, where you viewed the not crawl space, where you viewed the vantage point for the roof. There we go, vantage point for the roof. That's the only thing. It's got to be part of the promulgated form. If it's not there in the promulgated form, you can't add to it. And here we go. The inspector shall reproduce the text of the standard form verbatim. Spacing, borders, and placement of the text must appear identical to that of the printed version. So you can't have something inserted there and have it look identical. All of this is after the word comments. This is that blank section for you. That's sacrosanct. Don't put anything there. So an example right here. This is the way the promulgated report looks. This adds number of systems. I assume you're looking at my mouse. So the second section adds number of systems. That's not in the promulgated report and can't be there. And I can't delete energy sources here. That is in the promulgated report and I can't delete it. So you can see that you can't add photographs there. But after the word comments, you certainly can. In these sections that have places where it says other, you can delete other. You can delete optional systems. In my case, let's use appliances as an example. So after dryer, I can't do it anywhere up here, but after dryer, let's say that they left the refrigerator and I choose to inspect the refrigerator. I do that by making a comment. The only inspection I'm doing is to see if it's cold. And in fact, when the client's there, I'll open my hand and say, this is the extent of my inspection. This side is cold. This side is freezing cold. Looks to be working. That's about all I can do for a refrigerator. That's about the same thing we do for the air conditioner, isn't it? It says other, but since you can delete other and you can add, I would change the word other to refrigerator. And I would do a section for ice maker if I'm inspecting that, or compactor if I'm inspecting that, or washer and dryer. Now, those are all outside the scope of the inspection. But if I'm willing to document that I inspected it and willing to say that I did it by operating it in a normal condition, here's what I see, it appeared to be functional, then I can go refrigerator, washer, dryer. I can also just say other appliances, and underneath other appliances, I can put little a, little b, little c, refrigerator, clothes washer, clothes dryer. You can do that. You can delete inapplicable subsections of section 6. So if we have no irrigation system, no pool, and an outbuilding, so that means that section A and B don't apply, and D, E, and F don't apply. I'm sorry, it says there is an irrigation system, but B, D, E, and F don't apply. Then I can change it to this. Delete what's not applicable and re-letter it. And there was some discussion about this, but I'm gonna stand by what I believe here and say that this applies whether you inspect it or not. So let's say that you have a landscape system that you don't use or don't inspect, and you have an outbuilding that you did look at and claim to have inspected. In my opinion, you still need to leave section A, landscape, and then you check it as not inspected. Don't delete that, because at that point, somebody can say, well, look, you didn't see it. You didn't know it was there. You would have inspected it if you were there. They're holding you accountable for something just because you didn't indicate that it was there and not inspected. So for example, if there is a septic system and a well system, and I personally do not inspect those, I show them as present, show them as not inspected, but I also go ahead and give the client some information about it, saying, I don't inspect it, but here's what you can do. You go to this website It'll give you information about these, how they should be inspected, how often, and etc. It lets them clearly know that I saw it and chose not to inspect it, but I'm not ignoring them. Hey guys, here's some other things you can do. We have an inspector that says they put a picture of it in the report even if they don't inspect it. All right. I do that for pools, wells, well, I do inspect the pool. But if there's something not functional there, I put it. I don't think you hurt yourself by putting photographs in there, so that's a good idea, and I do it myself in certain places. Departure provision. Well, we talked about it, so let's see how we invoke that. Well, we talked about this in detail this morning, so let's just go to this next section. Make an appropriate notation on the inspection report form stating the reason the component or system was not inspected. Well, let's take an irrigation system. That's an optional system, and I suspect that many of you charge an upcharge to inspect that. And if the client doesn't want to pay to inspect the sprinkler, then you might just simply say not inspected at the client's instruction, not inspected because, or you can just say not inspected. Inspector and client agreed that it was not going to be inspected. How about a swimming pool? Not inspected. That I don't know that I'd say I wasn't qualified to do it. You could say the client inspector agreed that it was not to be inspected. Recommend an inspection by whomever. So don't just say not inspected. It does say you need to tell the client why you didn't look at it. And that would go back lack of gas. And I talked about the water heater. It was inspected, not inspected. I looked at it physically, but I didn't look at it functionally because the gas wasn't installed. There aren't a whole lot of things that I say I'm not qualified to inspect, but there are times that I will do that. I'll just say that, for example, solar panels, when I have seen them, I said, that's simply outside of my knowledge base. I don't know anything about it. I'm not qualified to inspect it. Generators, I'm more qualified than I used to be. And I'm very specific in what I inspect and how I test it. Well and septic, I don't consider myself qualified. I say it wasn't inspected, and here's what you should do. Reasonable judgment conditions exist that prevent inspection. Well, I told you a while ago about the fishing poles, and somebody made a comment about the classic cars, or just any car that's blocking it or personal property. How about vicious dogs? We had an inspector that was severely injured because dogs got out. Well, they were in a cage, a kennel, and they got out. But who's to say that barking dog's a friendly dog that likes to make noise, or that dog's going to attack somebody? If there's a dog in the yard and it's loose, I didn't go in the backyard. If the seller's there, I'll ask them to contain it. If the seller's not there, it didn't get inspected, and I report it. And I tell them that if I'm to come back to inspect that area that wasn't available, there'll be a reinspection charge, and let them argue about who pays for that. Somebody said there was a locked door. How many times have you come and there's closets that locked because that's the seller's gun closet, or that's where they keep their expensive stuff? How about you can't inspect it because someone was sleeping in that room? They don't want me in there. If there's a reason and I can't inspect it, I'm going to document it. And that's why I take pictures of the windows I can't get to, because there's some expensive vase in front of them. Or how many times does a exterior door in a garage get covered up by all those things that are stored, and the door opens in, you can't inspect it. Reasonable judgment, and then just document that. Here's why I couldn't inspect it. Common element in the multifamily development, condo, townhome. It's not in physical contact. So a ground floor unit on a 3-story building, there's no attic space in contact with this. The roof. I'll mention that the roof wasn't inspected. Generally, it's because I can't reach it. And then I'll tell them that they should find out who's responsible for it during their option period. Foundation in another building, or a part of the foundation in another unit. So we have a middle townhome, and I'm not inspecting the foundation on either side. I'll look at the common walls from this unit. I'll look at the fire stopping from this unit's attic space, but I can't tell you anything about the adjacent property. And we still know that they might have a roof leak or evidence of a foundation problem that I just can't see. Reasonably determine that it's hazardous. May cause damage to the property. I think I've used the description before of the ceramic donkey I have where I broke its ear. And I use that as a self-reminder that I'm not going to climb over things to get to a window trying to be better than everybody else. I'm okay with not inspecting. I take that picture, say I didn't inspect it. If something is found afterwards, I have followed the standards of practice. If you depart from the standards, you've got to note the departure. You explain what wasn't inspected, and you explain the significance of not having inspected it. I didn't inspect the electrical panel. I didn't inspect it because it was raining. What I might have missed is evidence of improper breakers, improper bonding, lack of bonding to the cabinet, lack of bonding to the raceway, anything that you think might be missed in there. And then what's your recommendation? You recommend that it be further evaluated, whether by you or an electrician, when it's dry and accessible. Here's an example. Why did you depart from the standards? Couldn't get to it. It's too high, too steep, too wet, lightning. Vantage point is the ground or the ladder. So if you're looking at it from the ground, binoculars, or even looking at it from a ladder where you put your hand on the roof, what can you miss? Well, there's a lot of places that you're going to miss things like the valleys and flashings, especially above and behind fireplace chimneys. And what do you recommend because you didn't inspect it? Well, kind of depends on the age of it, but I would recommend that they have it inspected, whether by you or somebody else. If you didn't inspect it because you couldn't reach it, then you're recommending that it's inspected by somebody who could reach it, which would basically be a roofer that comes with a tall ladder, or somebody with a drone. Alarms. Why did you not test the alarms? if you didn't test them, what might be missed, and what do you recommend? Well, I test the alarms if I can get to them, unless I think it's a part of a monitored system. Yes, I have had the police come. Yes, I have had the fire department come. But that was because they had the alarms tied into a security system. So they were monitoring the security system. They were monitoring alarms as a part of the security system. When it went off, they called the homeowner who didn't respond, who sent out whomever, the police or the fire department. What might be missed? Functional alarms. What do you recommend? Most of the time, I end up recommending that they replace all the alarms. There are times that they're old and I simply don't test them. I might even take one down to prove it's old and put it back and say, no sense me testing them, they all need to be replaced. Remember that manufacturers typically say they have a lifespan of 10 years. So if it's older than 10 years old, it just needs to be replaced. Also, in today's world, post 2009, the code 2009, that's when the introduction of carbon monoxide alarms on every floor and immediately outside the sleeping rooms came in. So if I have one that doesn't have those alarms, I recommend that those be replaced. And if I recommend replacement, I recommend that they all be replaced, not just certain ones. This one's old. This one's 11 years old. This one's 8 years old. Replace them all. We used that as an example. We'll discuss it again. The earliest possible point. If you never inspect them, then you talk to them very first time. You tell them that when you're in first contact, when you're discussing them hiring you. Roof and electrical systems are probably the biggest. If anybody can think of something that they routinely don't inspect, well, you got the T&P valve and you got smoke alarms. I know I've seen some reports where the alarms are not inspected and there's absolutely no documentation of the fact that the alarms weren't inspected. You don't necessarily have to inspect it as long as you disclaim it and say what you might have missed. Standards of practice update. Okay, in 2016, there were frankly very few changes other than changing ampersand to and some spelling and some things. The proposed changes to the SOP are posted on the TREC site in the minutes of the meetings. And I believe they may be posted someplace else. And I know that Derek posted them on Facebook, on TREC's Facebook page this past week. And there were some comments I saw made. So if you remember that Facebook page, you can go look at it there. Otherwise, you can go to TREC and look at it. Remember that at some point, it's going to be opened up to public comment. So you'd be better off reading that and making your comments before it's adopted and you don't have time or you don't have the opportunity to make comments, because look how long it's taken to make significant changes. It'd be 2008 to the changes that'd be now. Where do you find them on TREC? You would go to the meetings, public information, meetings, agendas, and minutes. Since I'm running all these screens, I can't do a search for it, but Brenda, maybe you could search for it and post it on there as an answer. But it is on TREC under meetings and minutes. and specific standards of practice. Okay. Whereas we didn't have enough time this morning, we're going to have plenty of time this afternoon. So we do have an opportunity to answer questions. And Shannon just made a comment there. Jim's comment about the face panel board is accessible. That's assuming that the cars aren't parked there and the storage items aren't there. So the things that would stop you from inspecting the panel board is things in front of it and perhaps the builder. We have a comment about an FPE panel. By that, I assume what you're suggesting is that you do not look at a panel, you do not open a panel if it's an FPE panel. I still open FPE panels because we know that insurers have problems with it, either won't insure it or charge a premium. We also know that there are problems, there are potential problems that might not show up in that particular panel. It still means it's unsafe, potentially unsafe. But in and of itself, the fact that it's an FPE panel does not keep me from opening it. If it keeps you from opening it because you feel it's unsafe, then you need to document exactly why you're departing, since you are required to open it. We've had discussions about all of these panels before, and I ended up doing some research because I was just frustrated by the lack of consistent information. And how many times have you heard that FPE panels have a recall, Bryant panels have a recall, Sylvania panels have a recall, Zinsco have a recall? I cannot find any evidence of a recall. What I find evidence of is class action lawsuits, not class action lawsuits, yeah, class action lawsuits and lawsuits, none of which resulted in a true recall. You had some that got sold or bought, but I don't find any evidence of recall. And if you do, I'd be happy for you to send it to me. We have a comment on there that there was no recall, and I think you're talking specifically about the FPE panel, but we have all of the others. My point is that it's not been recalled, but there are known safety issues. Have you heard what, okay, I'm trying to keep up here. Have I heard what any proposed changes are for the TREC report form? Yes. I want to make sure that we go through this because we're not talking about the new form, we're talking about the existing form that many people have problems with. But you can go to that same TREC site, you'll read the standards of practice, which make it obvious what changes there will be to the form. And we'll leave it at that right now. A city, I'm reading, I know that it's a discussion on a regular basis. A city inspector came out and passed the panel. Well, now you get into that whole pass-fail thing. If the municipality or if the authority having jurisdiction wants to quote unquote pass the panel, all they're doing is saying they're not going to make anybody remove and replace the panel. To me, that's less passed than tolerated. But the insurance company is the one who will say, I'm not going to insure it. And from a safety point of view, you're still required to pass on the information, I think. But there is no requirement that anybody do anything to a house. We're simply saying this is an FPE panel that has known problems. And my comment is, I don't care what the condition of the panel, what it looks like today. The known risks with this panel means that the problem can develop tomorrow. So I'm going to do everything I can to help them understand it. We have, let's see, let me scroll down. Okay, shouldn't the panel be replaced? My opinion, yeah, it should be replaced. We have known issues, but I can't make anybody do that. Do I recommend that it be replaced? I recommend that it be further evaluated. I'm not going to take the responsibility for saying it should or shouldn't be replaced. What if we get into a discussion about electrical cables that are the old cloth wrapped ones? Should those be replaced? Be a great idea. Does it have to be? Well, not if there's not any damage to it. We just know that those aren't as safe as some others. So report it as a safety issue. Let them decide what they want to do. We see that Brian posted on here a link to Dropbox, so you can go there and see the information on the proposed changes and I assume the form. Jim Heim, I'm not certain what your comment there is. Inspectopedia, okay, typo, I didn't see up ahead. So are you saying that on Inspectopedia there's some particular information? I have looked at those, and yes, I've seen at times they say there's a recall, but not that you can prove other than they said it. I think they said it in error. No recall that I can prove. Okay, so let's go back here. Standards of practice structural system. So given what we talked about, what cannot be deleted, what can be deleted, what can be added, this section, you cannot delete anything other than L, other. And in L, other, you can either delete it or you can add to it. So other can be changed to, let's see, what might be a structural thing you can add? How about flat work? Now, flat work is specifically disclaimed in the standards of practice. However, if you are also an ASHI inspector, ASHI requires that you inspect flat work. Cabinets are specifically disclaimed in the standards of practice. But if you inspect, or if you are ASHI, you have to report, you have to inspect cabinets. Now, I know some people put cabinets, I've heard, in walls. I don't like to confuse it, so I just make a separate section for cabinets and say I don't inspect it, even though at times I might say, even though it's not inspected, I see this. Countertops. You could put cabinets and countertops, or you could put cabinets and then countertops. And again, that goes back to ASHI's SOP. But what you can do is delete other. And if I'd have just looked at my notes, you'd have seen this, energy conservation. I'd put energy conservation in new construction. And I've begun doing it in the homes built after 2015, if I'm inspecting them without regard to whether it's new or not. The 2015 Energy Code was adopted by the state of Texas, and they adopted it saying that they would not adopt any energy code in the interim between then and 2021. There's no guarantee that they'll adopt 2021 anytime soon. I'm simply acknowledging that. In energy conservation, I'm saying a couple of things. I'm saying first, there should be the certificate posted in the panel box. There's a couple other places, but for the most part, you're going to see it in the distribution panel. It should be on the cabinet or inside the cabinet door. I talk about insulation in attic, but here I make the comment that I don't know what energy path they take. There's two, prescriptive or performance. And without knowing whether they take the prescriptive or performance, I don't know whether an R30 is acceptable or it has to be an R38. So basically I'm saying you've got some information that I would love to tell you about, but I don't have enough information to do it because they haven't posted the certificate that they should. Electrical systems. Well, those are the two. There is no other. You can't delete anything. But I did tell you that I add subheadings. And this, by the way, is mine. So I break down under service entrance and panels, distribution panels, and bonding and grounding. I do that because bonding and grounding is such an extensive category in and of itself, and I don't want to put it down as an item C. It's there in service entrance and panels. So that's the way I break it down. Branch circuits, connected devices and fixtures. I also have a subsection for service disconnects. And I do that because of how many service disconnects don't have adequate clearance and how many service disconnects are missing from electric water heaters very often, and condensers less often. So in my case, it's service disconnects, receptacles, outlets, and fixtures, GFCIs and AFCIs. Now, the new standard of practice, the proposed standard of practice to be looked at apparently on Monday, is going to introduce a discussion of AFCIs missing as a deficiency. But that's being put in service entrance and panels. I understand there's been an awful lot of discussion about it, and I think it's being put in service entrance and panels because most AFCIs are installed in panels, but there are AFCIs available now that are similar to the receptacle type GFCI. So you have a receptacle type AFCI. In my opinion, an AFCI is protecting a branch circuit exactly as a GFCI is, and I believe it should be branch circuits, and that's where I put it right now. If it passes into code in the service entrance and panels, then obviously that's where I'll have to put it. And then carbon monoxide alarms, you've heard me already say that. Okay, Stephen, location still pending, but protection may be in either. So it seems like you're saying that the location of AFCIs in the revision may be in either place. But yes, we could have protection either as receptacle or as a breaker. I think that's what you're saying. Everybody, that's why you have to read the proposals and be prepared to make comments. Thanks, Stephen. Question. From time to time, I get to a house and there's a strong odor, such as a musty odor or strong smoke odor or a strong urine odor from pets. Where do you put that in the report? Okay. First, because there's a tendency for some people to ask silly questions to get me bumfuddled, I'm going to assume that this is a serious question. And it has a strong odor. Well, if you think that odor might be carpet-borne or wall-borne, then I would suggest that you put it under walls. If you think it's carpet, I think you'd put it under floors and disclaim floor coverings and say that the odor is there, and it is more likely than not, if you are confident about it, odor absorbed by that. More likely than not is verbiage I got from an attorney, and it's basically better than I guess or I think. You're saying that the odds are in favor of it being there. So if it's a serious question, I would say that it could go either in walls or floors. Okay, thanks, Stephen. It's basically what we've said. What Stephen is saying is that a decision has not been made. It could be in panels or branch, not decided, but regardless of the where, it's proposed that the lack of AFCIs be considered a deficiency. What about traps? Okay, Lee, I guess the question is, if you're talking about traps and drain lines, you report it under drains. If it's a trap, missing trap in AC system, you report it under AC systems, under the cooling systems. He's talking about odors. Well, if you have an odor in a trap, I still think it goes back to drains. An odor from a sink in a vacant house might simply be that the trap went dry and you're smelling the sewer gases. If it is a trap in a house that's occupied and the bathroom is used, I would see if anybody mistook the sink for a toilet. HVAC systems. And yes, that was me being smart. Maybe. Can anything be deleted here? No, not really. Can anything be added here? Well, you can add some things to duct. I mean, you can break down the others. You could probably create a subset. You could create a D for dehumidifiers. You could create a D for ventilation systems. So it'd just be how you would choose to handle that. I do document the presence of dehumidification systems because I have to be able to say, you know what? I didn't inspect that. I'm not inspecting or measuring humidity in the house. And even if I were to measure humidity, I couldn't tell you that there was a pattern of high humidity. I can tell you it feels humid, but I can't tell you any more than that. Ventilation systems, fresh air delivery systems, about all I can do is tell you it's there. I can't determine whether it turns off or on, whether the damper opens or closes. So I acknowledge its presence, so it doesn't look like I was not a professional and missed it. Here it is. I see it. I can't tell you any more about it than that. What are my thoughts on reporting SEER? My concern is that you can't accurately determine the SEER without knowing the compatibility of the installed components as well as how they were installed. which is beyond the SOP. Not only is it beyond the SOP, it is specifically disclaimed. It says we are not responsible. We do not have to measure or determine the compatibility of the systems. And the proposed SOP actually takes that out in a little bit more detail, which I liked. So what is my thoughts on reporting SEER? If I report SEER ratings, I report it as the nameplate rating. I don't pretend any more than that, even though I know that it is likely to be more or less depending on how the system was installed. So I get that. That's it. Here it is. This is what its nameplate ratings say the SEER rating is. Now, if there is an Energy Conservation Code certificate posted and the SEER rating on that label is different than the SEER rating on the manufacturer's plate or manufacturer's sticker or whatever happens to be there, assuming it's not washed off by rain, I'll note that there's a discrepancy that I can't reconcile. I don't pretend that I can reconcile it. This says this says this, but there are ways that they can make it achieve that. Enough said. Zone system. Do I check zones to see if they're regulating these areas? When I have multiple systems, I will try to determine that they are handling specific zones. So if we have a one-floor dwelling with two systems, I'll operate them one at a time to make sure that there's not something disconnected or missing. And I do that to be able to explain to the client that this system is handling everything to the right of the kitchen wall, and this one is everything to the left, or that this one is bedrooms only. If it's two floors, then I'm less concerned with that. When I'm checking air temperatures, I can pretty much tell that one isn't cooling. And yes, that may mean that you have a first floor system controlling one duct on the second floor, but frankly, I don't expect that to be a problem. So no, I don't try that. So one floor, two systems, yes. Okay, these are my comments about the form, not in the form. This is just a discussion with you. Everything you do, as you follow the SOPs with regard to completion of that form, you have a lot of freedom. There are an awful lot of things that you can do to make that report stand out as your own. The photographs, how you do it, how you lay it out, extra information you provide, information on maintenance that you think the client would be happy to know about. I show the client how to, what the purpose of the backflow preventer on the air gap on the countertop of the kitchen is. How many times have you seen that when it's turned facing the counter backsplash, or has been removed by the client, not by the client, by a seller, because it kept spilling water out? So instead of knowing enough to clean it, they just got rid of it, creating a problem with their dishwasher. So if I explain that to my client as something they should do for maintenance, wow, I get a lot of kudos for teaching them something. And I put that in the report so they can refer to it as maintenance. We talked about a client going in the attic in order to see the filters. How many times have you seen a large media air filter in the attic that had never been changed, and there were filters downstairs? And that all comes down to somebody didn't know it was there. They forgot it was there. I have found large filters, one that was over 7 years old. Now we know that's affected the performance of the system, but that also means that that seller or the homeowner never bothered having the system inspected or serviced. That's something to tell the client. It's obvious the system's never been serviced, and there is a filter, and you should change the filter. Same thing with the ventilation system. Some of them are replaceable, some of them are washable. Same thing with the grease screen underneath the microwave serving as a range hood. So there's a lot of things that I'll tell my client about that they simply didn't know. And I put that in the report. Yeah, it makes the report a little longer, but I don't mark it to look like a deficiency. I use the word information. Hey, here's information. This is maintenance tip. This is safety, things you need to know about, things you need to maintain. It's not deficient, it's just add extra information. Does that mean that an agent might not use me because the report's too long? Yeah, and I don't care. The client's the one I'm taking care of. If the seller is present and makes comments about the home's repairs made, upgrades, do you put the comments in the report? For instance, the seller comments that he made all the upgrades. 2 electrical receptacles are not functioning, and the seller hasn't been able to figure out why do I document that. If I had a comment like that, I would and have said that it's based on those comments, more likely than not, electrical changes were made without a permit or inspection. Sorry, it was made without a permit or an inspection. And that in and of itself would be reason to recommend further evaluation by an electrician. If they say that there's repairs and upgrades, and it's not like something that would need a permit, then TREC specifically excludes my requirement for reporting it unless the repairs and upgrades weren't done in a workmanlike manner.
You know, Clay, a lot of times we'll get to an inspection and someone's brought out the plumber, air conditioning contractor, or someone else at the job site while you're there. I always take a picture of their truck, get their name, and I'll put that in my report too.
And then, Tim, your comments, just what I said. If it's not done in a workmanlike manner, and it's workmanlike, I believe, then that's reportable. But in and of itself, the upgrade isn't reportable unless it would be something without a permit. During the break, somebody came to the door and delivered this. It is, there you go. You're not going to get it, but it's the, I am now certified as a real estate instructor from the Texas Real Estate Teachers Association. So Paul, does that mean that today counts?
Yep, today will actually count you as an instructor. You qualify.
All right, that's just a little more effort, one more plaque to put on the wall, like I needed another plaque on the wall. Okay, so what this comes down to is that everything there is to allow you to make this your report, make it stand out, make it distinguish it between yours and others. Thank you. If you have, okay, we have a question. Some reports I've seen don't really have a D or a C by a comment. They're just long running comments. Shouldn't they be clearly identified as deficient or comment? Well, you're asking an opinion there. I believe absolutely that if you have something written under one of those sections, your client needs to understand that that is something that you are reporting as a deficiency or just information you're providing. As an example, in mine, if I believe it is a reportable deficiency, I highlight it in yellow. If I'm just providing some information, I use the word information in italics and then I make my comment. If I tell them that I can't see something or that I am departing, I use the word notice and then describe what I can't do and the departure. So you're going to make the report better if the client can understand it. Do I think it should just be run-on sentences? No. I think you're better off with shorter paragraphs because a client's not going to sit there and read the whole thing. Okay. All right, so we're there where the next thing is the test, and rather than going into that, because I don't want Brenda to have a heart attack and everybody have to, or Paul have to give her resuscitation there. We've got the test to do, but if we were all in a room, we would do this with questions, and I think we ought to take time to do that. So what are some other questions that you would present to me or Paul or Steve, since he's with us? What would you ask? Nothing?
Oh, come on, guys. We've got Steve Reinhardt and Bruce Carpenter that are both on the IAC committee here. And
I'm sorry, I forgot you, Bruce.
go ahead and ask questions, and we'll let those guys throw it in the chat box, and we'll overdo it.
Good questions. Okay, let's just start. I want to verify again that I can remove other section and add like driveway or cabinets. Yes, you can delete the other, but if you're adding, essentially what you're doing is just changing other to cabinets. I wouldn't recommend that you use the word driveway. I would use flat work. Flat work is going to address the driveway, the sidewalk, and the walkway, and the back patio, and anything like that that is not a part of the foundation.
You know, the word flat work, to us, we understand it, but when you're talking to that consumer, driveways and sidewalks, so much clearer to them.
Except that I define flat work. If you say something that is like that is not going to be understood, the first thing you do is define it. Paint overspray in the electric panel box. Well, that is absolutely incorrect. They shouldn't do it. The manufacturer of the panel box says replace it. But what's the reality of it? You're going to have to decide if the amount of overspray you see is material. It might not be enough to have an effect on the panel. If you want to say you see some overspray, if you want to get really aggressive, you can say the manufacturer's representative needs to look at the panel and see if it needs to be replaced. That takes you completely off the hook. If you want to say, I see some overspray, but it doesn't appear to be material, you can say that. Kind of your choice. Mark says, give us a moment, we'll come up with some. No. As an instructor, do you, Jan, get paid more? No. I inspected a home the other day that did not have HVAC vents in the kitchen and the laundry room. Should I have written it up? Was it designed that way? Maybe they felt that it would be accurate. The laundry rooms in an older home didn't used to have vents. In a very old home, the bathrooms didn't have vents. Should you have written it up? When I see that, I write it up, not necessarily as a deficiency, but hey, information. There aren't any vents in there. So you're going to need to make a real effort in a bathroom to make sure that it doesn't have, it doesn't develop mold and mildew from high humidity, and you need to make an effort to leave that door open so that it can vent out.
Don't write it up, Clay. That's when you'll get that call back and say, I wish you had told me.
Yeah, you need to tell them something. Now, if it's a newer home, pull out your thermal camera, because I bet that they covered it up with drywall. I have found that 4 times. One was in a home that was 15 years old. One was in brand new construction in the media room. And two were just dining rooms, and it was just kind of odd places. And it was there, and they just covered it over. And when they finally removed the drywall on that one that was 15 years old, you can imagine the mold that was there. I'm sorry, the suspect organic growth. Yeah, it was mold from that cold air hitting the hot ceiling for 15 years. Am I using split readings to determine functionality of the heating system? No, unless it is electric. On the furnace, what the standards of practice says is that you look at the quality, basically, of the flames. You're looking for color, uplift, anything that shows you have a poor drafting problem that might be anything from the gas flue and its design, or damage, or heat exchanger. Is the branch circuit from a panel to the first AFCI receptacle considered protected or unprotected? Branch circuit. Okay, not certain here, Ray, but it's if there is an AFCI in the panel, everything downstream of that AFCI is AFCI protected. If you're talking about an AFCI type receptacle, then from the panel to the first AFCI is power, is current protected. I don't know if the AFCI would have an effect of upstream, but since I've never seen an AFCI receptacle, I don't know how significant an issue that was. You may have to tell me more about your question. Okay. Why do we require all aluminum conductors to have antioxidant paste in the SOP? Steve and Bruce and anybody that's been doing this a long time, you can maybe answer better, but my answer is that was because that's the way it was written 20, 30 years ago, and it hasn't been changed since. If you're asking me, does it need antioxidant? I would have to tell you that the manufacturer of the cable, the manufacturer of the overcurrent protection device don't require it, because we only see stranded, but it's still in the standard of practice. So I just say it is required to be reported, and it may be a best practice, but that that's about as far as I go. Do I think it could be removed from the standards of practice? Personally, I do, but it hasn't been. Are there any requirements in the report, in the SOP, to report on CO2 detectors? Current standards say you report if they are not functional. I'm not looking at it, but I believe that's all that it says. If there is a CO2 detector, you're supposed to test it to see if it is functional. I add to that, if it is older than 10 years, I also report it as deficient. And I also, as information, tell them where else it should be. Where I put as information, here's where they're supposed to be located if they're not all there. So for example, if I have a hallway outside bedrooms that does not have a combination smoke carbon monoxide alarm, I report that as information. Is there a way we can benchmark our report with others to share best practices? You know, we've discussed that many, many times. What it really comes down to, and we talked about it, doing it at a TREC state level, offering to review reports. The problem is that we already were busy and couldn't spend the extra time reviewing reports. But I'll tell you that probably the best way to do that, and I have done it, is to share my report with others and to have others share their reports with me. And we kind of went through it, and everybody pointed out their information or their comments, their suggestion. I'll tell you that I made changes to the way I did some things because of that. They made some changes to the way they did some things. So I would suggest that you find somebody to partner with, find several somebodies to partner with, so that you don't have one person trying to do absolutely everybody's. It's great. Find a way to share, find somebody to share. I'm very hesitant to say that send it to me and I could do it because I don't have any time, but you find somebody. Okay, we're getting some questions in both the chat and the Q&A, so be patient with me. How would you write up when the microwave exhaust fan is configured internally, yet the external ductwork is in place? I assume you mean that it's configured to recirculate and they've simply ignored the fact that there's ductwork. That's the way I report it, that the microwave recirculates, but ductwork is available and it could be reconfigured. And I find more often that they have the fan in backwards, and so it recirculates. Now, that it neither recirculates nor exhausts. So all that's happening is all that air is being blown up to the underside of the cabinet. I've seen an inspection form where the boxes are checked, but under comment it says see attached and then you get the report. I've seen that too, and what it looks like to me is that they want to use reporting software, but recognize the reporting software doesn't meet the SOP. So they go through and check the boxes and then ignore the form and use the software to create their report. Do I comment on temperature? I assume that means temperatures in attics or damage that comes from extreme heat, black shingles, no venting. I absolutely do. And I'm basically reporting improper ventilation or poor ventilation under attic spaces. And then I'm saying that here's the effect of that poor ventilation that I observe. I observe that the roof cover is deteriorating at an accelerated rate. I report the humidity in the attic itself. So the deficiency is ventilation. Everything else is the result of poor ventilation. Let's see. If adding information, can you copy and paste the check boxes in another place in the report? I'm not sure I understand the question. if you're asking, can you cut and paste or copy and paste, the answer is yes. But I think what you may be talking is how it relates to the SOP. If you clarify that a little more, I might be able to answer. How would you report the absence of an exhaust vent over a gas range in the kitchen when there's no code specifically requiring it? Well, that goes back to first, it's not a code inspection. And I say that because if I'm not mistaken, there is, in the newer versions, there is a code requirement for an exhaust vent under certain circumstances to do with how tight the house is, because now the energy code makes the houses so much tighter. If you don't have an exhaust fan, you have a problem, but there's also a requirement for makeup air. So let's take that off the table. And you simply are acknowledging there's a gas range with no exhaust vent. Well, you have to have clearance between the range and combustibles. So if you
have you got a picture you can share with us on that clearance, Clay?
Paul, are you being a smart ass?
I thought you had a good picture, Clay.
Yes, you are. How would you report the absence? So if there is no fan and you have less than 30 inches of clearance, then you have a deficiency because you're supposed to have clearance to combustibles. So is the problem that the clearance is too low because the cabinet's too low? Then you can report it under cabinets, which is not required, or are you just going to report it under range? Or you could say that there is no exhaust and there is no metal of any sort and just recommend it. But you're right, there's no code that required past tense. So it might be something you want to do. All right. If the cooling system is a swamp cooler, period, my answer is, I don't know. I don't see swamp coolers. I have no experience with swamp coolers. So if there's somebody here that would like to answer that, go ahead and I'll look at the other question here. Who knows about swamp coolers?
Steve Reinhardt answers the question and said it's not uncommon to check up to 3 boxes. Just explain what you're doing. You know, that the system may have been de-winterized, but these are deficiencies that I see. And, you know, check the inspected, not inspected, and deficient box. I mean, as you can do all 3 of them.
Okay. Okay, so Paul was talking about a missing vent hood, and he says that he'd refer back to the manufacturer installation requirements. I assume, Paul, that's to the range to see if a cooktop is required to be vented, or to the vent hood itself to see if it's required to be vented.
Yeah, you're asking me which one?
Yeah, I'm asking you what you're talking about.
Yeah, well, I was talking about your clearance from the bottom of the vent hood to the top of the range.
Are you still talking about the microwave?
Yeah.
Well, you do have to tell them the story. Really, you do.
It's so good, Clay. It just doesn't get old, man.
All right. I don't know if I can find the photograph, but it was preparing
Everybody close
for
your eyes and envision this.
what?
Everyone close your eyes and just see if you can envision what Clay is saying.
All right, here we go. There was a training class where I presented a picture of a microwave that had melted. The door had melted and there was a Band-Aid on it. And when I showed that, people were mocking the installer, saying that clearly they did it wrong and it was too close to the range. And somebody laughed and said, look, there's a Band-Aid on it. And I said, yes, I laughed when my wife put that Band-Aid there, therefore acknowledging that I was the one who installed that. But it was installed to code and per the manufacturer's installation instructions. But yes, we did melt a microwave. Thank you very much, Paul. I'll post that if I can find it.
Yeah, no problem, Clay. I'm always glad to help you.
Yeah, you are.
Thanks, Paul.
You're welcome, Glenda. Glenda will find that picture, I'm sure.
Uh-huh. Let's see. Okay, did that the other day. The air return was covered up. That goes to lack of a supply air vent in a room. On a final inspection, I wrote up the gate. All right, fences and gates are specifically excluded, but I too have written them up, certainly in new construction. And I have at times added under optional fences and gates and said that while it's specifically excluded, I noted that in general, the fence and gates were in poor condition. And if they're metal and there's a lot of corrosion, I do the same thing. I'm not required to, but that's enough of an expense that I think it helps my clients to do that. Are S-traps under the sink in older homes okay when there's a P-trap on the drain under the home? S-traps are not acceptable. What you're saying is there's a P-trap downstream that might still hold water and not lose it because of the siphon effect on the S-trap. I don't think I want to get into the argument. I think I'm going to say there's no S-trap. Or there is an S-trap and there shouldn't be.
Yeah, Steve Reinhardt also answered that for us and says his opinion, no, but he said he's just a plumbing inspector.
Where'd you read that? I'm not seeing where he's responding.
Underneath the question, it says
Show all.
show all. If you click that, his comments underneath it.
Oh, so I was right. Good, thank you.
Thanks, Steve.
Okay, let's see. I inspected a home with its own separate air handler with input and 2 output registers, the thermostat installed in the garage. It's answered. Thanks, Steve. Gate clearance to the
comment, because others may not know how to get to those other comments too.
okay. Basically, the discussion there is that there was the supply air registers were in the garage, and sounds like return air were in the garage, and it was thermostat there, but I can't see from that it was dedicated to the garage or if there was some sort of interaction with the house. If there was, it's a deficiency for fire safety. But if there was no, if it was standalone in the garage, as Steve replied, then that's okay. You just can't have anything that compromised the ceiling or the walls for fire separation. We have someone who wrote up the clearance to the service meter and asked if the clearance to the service meter is the same, requirements are the same to the panel box. And I believe they are. I'd have to go hunt that down, but I seem to recall that you still have to have clearance there at the meter. I see main panels replaced at homes without AFCI breakers installed. And sometimes on new construction is a deficiency if it's obvious the panel was installed after 2008. If I'm doing new construction and they don't have the AFCIs where they're supposed to have them, yes, I write it up. If I see that a panel has been replaced without AFCIs, I don't write it up, because it is the wiring methods that could cause the AFCIs to trip. One of the biggest problems were when the cables were run one on top of each other and the staples were sort of overdriven that put the cables so close to each other that you'd get induction causing tripping on the AFCIs. Or if the cables were installed on the end, not flat, but on their edges, the staples would create that within one cable, and it would have false trips. And if you've heard Wayne Rogers say before that the older homes, it is not practical or feasible to bring it up to code with regard to AFCIs. So older construction, no. New construction, I reported as a deficiency in the new construction. What's current thinking about reporting bundling of cables on the outside? There are a couple of issues. One is that if the bundle fills more than 75% of the raceway, it's wrong, and that's because of the heat generated. If it's less than 75%, then the issue is that the cables have to be grouped so that, and marked, so that you know that this hot, this neutral, and this ground are all together, and they're for the branch circuit at the primary bedroom. That's an example. But is it material? Well, if it's more than 75%, then it's potentially material. However, if you're in a 50-year-old home and there's no problems, then I don't particularly think that it's going to create a problem. I'll tell you that I report that as information. Here's what I see, and I don't see that it's an evidence of a problem or it has been a problem. Okay, proposed changes talks about moving information on gas lines, including appliance connectors, drip legs, etc., to a new section. And if it passes, we will need to have all that under gas section rather than the appliance sections. I'm going to tell you how I do it. And this all stems from a case years and years ago, because I've been doing it a long time this way. If you report it under appliance, and then you have it's not reported under plumbing, and then a plumber comes out and fixes things, and then they find out later that it's wrong under appliances, and they say to you, well, if you had just told us under plumbing, we'd have had it fixed then. So under gas ranges, water heaters, and gas furnaces, I have a blurb that says that deficiencies in gas lines and connectors is under plumbing. So I have essentially reported it in both places, and since it's such a common thing, it's in my comment, it's in my template, and I just delete it if it doesn't apply. For example, an all-electric house. So I still report it. I would change only that my blurb refers to that new section rather than just a freestanding comment under the appliance. Currently place deficiencies with thermostats under an added subsection D. Where do I list my findings? I would report it under, I don't have that too often, but if I did, I have reported it initially under heat and cooling. I just say both places I have a thermostat deficiency, or you could do it under ductwork, but I do put it. Jim talks about vent hoods required by ASHRAE, but Jim, is it you're saying an exhausted type hood, not just that there's a hood, but it has to be exhausted by ASHRAE. And then I'd ask you how long that's been around. One more thing to research. Oh, have a concrete porch, 5 steps leading to the top. The rise of each step is approximately 8 inches. Tread depth is 10 inches. Does this require a handrail spanning the 5 steps? Well, you say 5 steps. What's the height, the total height? That might require it. I would have to do a little research on there, but I don't think I'd have a problem saying you ought to have a handrail, whether it's recommendation or deficiency. Report it as deficient. What are they going to do? Come back and tell you that no, it's not? Say, okay, I think it'd be safer to have it there. Are ride-along instructors charging for training? If so, what would be an appropriate fee? Paul, you still charging $1 million?
No, I went up just a little bit because of that.
All I could do is you're going to have to talk to the individuals. I don't know. I have not heard anything that is standard. I haven't had anybody I've talked to come close to each other. It just, you're going to have to talk to them.
I like Steve's Reinhardt's comment. It said 1 truck payment. Market your skill and experience at what they're renting. That's what they're renting. That's a good idea.
Tom, are you close to Montgomery County? Because I mean, Paul's not doing anything. I've seen HVA systems in garage where the home was once a model home, and that's where the offices were. You're going to have to see. You're going to have to see if they've left it where it compromises the attic space. Steve talks about he sees it in every model home, usually way oversized. Most of what I see down here is that they take the HVAC system out and they patch the ceiling. That's what I see, because the builders aren't going to leave that AC behind. It's the man cave installations that cause the most problem with fire separation. Okay, let's do this. No more posting. I'm going to see if I can't get this through, and then we do the test. Disconnect has to be in a direct line of sight or within 50 feet. So if it's around a corner, I look at it and I just kind of make a judgment call. If it's a fence between them, I report it. Okay, 10 gauge conductor on a 40 amp breaker for an AC. Manufacturer, nameplate says minimum 25 amp, but that's not a minimum breaker. That is a minimum circuit. So that I would say that, well, 40 amp breaker could be up to 12, or no, I'm sorry, that's wrong. I would say it's wrong. Even though the minimum circuit size, the 10 meets that, the 40 amps still above it, so the wire size is still the weak link. Two-story home, HVA unit, baffles control of flow. How do you check it? I do it one floor at a time. Set the thermostat for the first floor and make sure I get it. Check the set the thermostat on the second floor after turning off the first floor. What's your response when you see CSST or flexible gas line connectors inside the fireplace? I say that I don't know if it's rated for use inside that firebox, and I recommend, but I think personally it's unsafe. I'd look it up, but personally I consider it to be unsafe. Are grounds allowed to be double on bus bar? We're talking specifically grounds, not neutrals. Yes, depending on the manufacturer, but most often, yes. And in fact, Gary made a comment, some allow 2 or 3. Neutrals, absolutely not. Two houses where the HVAC did not have a standalone disconnect, but was within 10 feet of the panel. And the shutoff was the breaker itself. If it's within insight, within 50 feet, the disconnect can be the breaker itself. I made an inspection and the client did not sign my agreement, but paid at the time of the inspection. What can I do? Steve made a comment that for us, but I think you're saying for him, it's an insurance requirement. But you have to do that ahead of time. If you show up and you do the inspection without the agreement, the burden is on you. So Steve's comment is no agreement, no inspection. I've got nothing. We're done unless you have some questions, really.
All right, everyone. Thank you so much for attending the classes with us today. We appreciate your time Saturday and doing so. Stay safe and stay dry. And please remember, we will get these hours posted within the next 7 to 10 days.